Good. Item number 7. Your microphone may not be.
I beg to mention item number 7 and the
Yeah.
series, Your Lordship. We need some accommodation. The senior arguing counsel is not present today, Your Lordship.
One adjournment.
Yes, Your Lordship.
Adjourn on the prayer of your name.
NN Datta, Your Lordship.
And Datta and consent for it.
Would like to.
Item 1 for hearing.
In this matter, I may be given some time to go through the records because the reference and all these records are not furnished to us.
We'll take up after some time. Go
After
to,
some time, we may be permitted to go through the records.
go to the. Yes, item 2.
My lord, impugned order at page 41 also. My lord, I am declared foreigner mainly on the ground that there are some anomalies in the name.
Forget about the anomaly.
Otherwise, Lordship, I have a plea before the learned tribunal also that
No. Who is the father of this person? Who is the father of the petitioner?
Indra Mohan Toroni Das.
Where is his name?
His name appears in the relief eligibility certificate, Lordship.
Page number.
That was exhibited, Lordship, and that is at page 12, Lordship.
Page 12.
Lordship.
Indra Mohan
Toroni Das.
Toronidas.
It was exhibit A before the learned tribunal, Lordship.
How do you establish that the petitioner is the daughter of Indra Mohan?
Yes, Lordship. There is link document, Lordship. Page 21 is the certificate issued by Gao Panchayat, Lordship.
What is the source of knowledge of this Gaon Panchayat secretary that you were the daughter of that man? How does he know?
That is not mentioned, Lordship, but there is another link document that is Gaura certificate. Gaura also was examined, Lordship.
This Gaungura and the secretary, what is the source of your knowledge that this petitioner is the daughter of Indra Mohan?
Lordship,
Only certificate does not establish anything. From where they came to know?
Lordship may kindly see the statement recorded by the Gaura at page 37, Lordship.
37.
This is the evidence in affidavit filed. by
I
the-
further declare that she is a citizen of India. So Gaungura is now the authority to declare somebody. What is this? At the outset, I beg to state that she is not a foreigner. I say she was born in the year so and so as per family horoscope and electrophoto related to Indra Mohan Das. This is not evidence.
Lordship, they were mainly the victim of religious persecution, Lordship. That
There
I
may
have,
there may be any kind of victim, but
that-
you established that this Minoti Das is the daughter of Indra Mohan Das.
these are
You
the,
have to establish it.
these are the documents only.
But these are, what is the veracity of these documents? These are strangers, one Gaungura. It's
Gam-
nothing like that, that the Gambura knows everything in this world.
My lord, in the
And
affidavit,
see the approach of the Gambura, he is declaring. As if now the Gambura is the authority in India,
yes, lordship,
who will declare who is a citizen, who is not a citizen. Bring some,
language should have been otherwise. lordship.
bring some better materials to show that this person is the daughter of Indra Mohan. That's all.
Lordship, Gowra is aged about 81 years, as mentioned in his affidavit, and he has.
Maybe, but he does not say anything. Gambura assumes the responsibility that he is the authority in India to declare a person to be a citizen or not to be a citizen. So I further declare that she is a citizen of India.
Lordship may kindly come to page 39. This is his cross of the Gowra, lordship. Cross of the Gowra, lordship.
Yes. Mr. Sharma. Whatever deficiency was there in the evidence, in your cross, you made it up.
Lordship.
Why do you cross a witness? To demolish the evidence that is rendered. And here is a case, he did not prove it on his own, but through cross, you have helped him to establish his case. Very well, we accept it. No? In the evidence in chief, nothing came out. Nothing came out in the evidence in chief, but in the cross, you helped the person to establish the case. You face the consequence. Declare for it.
Yes, lordship.
So he declared the person to be a citizen. What else to do? Firstly, you accept the declaration by the Gambura that the person is a citizen.
Yes,
Secondly, whatever deficiency was there in the evidence,
in cross.
in cross, you made it up in their favor. So we understand that the stand of the state is that this person is a citizen.
I know her background very well.
I know her very clear. I know the obviously the word she is residing nearby my house. I know the father who expired so and so. And I want to tell you. You are
M.I. Hussain.
M.I. Hussain. Heard Mr. M.I. Hussain, the counsel for the petitioner, also heard. The petitioner Minoti Das was referred to the Foreigners Tribunal number 2, Boko, Kamrup, for rendering an opinion as to whether she is a person who entered the state of Assam from the specified territory subsequent to 25/3/1971, resulting in registration of FT case number so and so, wherein an opinion was rendered that she is not a citizen. Being agreed, the state petition is instituted. The petitioner relies upon relief eligibility certificate issued by the Government of India Ministry of Rehabilitation, wherein it is provided that Indra Mohan Toroni Das entered India from his original village. What is it? Chamsapur. What is the name of the village? Page 13.
Yes, lordship. Saharanpur.
Not Saharanpur. Chamsapur, maybe. CHAM. CHAMA. CHAPUR, it appears. Yes, I know, whatever is the name. So village, police station Kendua in the Mohan Singh district of the erstwhile is Pakistan. And the date of arrival in India is 16/5/1964. From the information contained in the relief eligibility certificate, it is discernible that Indro Mohan Taranidas is not a person who entered the state of Assam from the specified territory subsequent to 25/3/1971. The petitioner adduces the evidence of Laban Chandra Boro, Gaungura of Sodhuripara, lot number 3, where Indro Mohan Taranidas resided subsequent to his entry into India. Lavan Chandra Das is stated to be aged about 81 years. In cross, Lavan Chandra Das stated as extracted till 39. A reading of the evidence rendered by the DW2 Lavan Chandra Das Gaungura in cross establishes the claim that the petitioner is the daughter of Indro Mohan Taranidas, inasmuch as the Gaungura had rendered evidence from his knowledge that Indro Mohan Taranidas had been residing nearby his house and he knew their family since long back. Accepting that the age of Lavan Chandra Boro DW2 is about 81 years, when the evidence was rendered on 5/9/2016, the evidentiary value of DW2 cannot be rejected in any manner, inasmuch as he had deposed from his own knowledge that he knows the family of the petitioner and that she is the daughter of Indro Mohan Taranidas. As Indro Mohan Taranidas had established, is not a person who had entered the state of Assam from the specified territory subsequent to 25/3/1971, and the petitioner having established that she is the daughter of Indro Mohan Taranidas, we accordingly hold that it cannot be declared that the petitioner is a person who had entered the state of Assam subsequent to 25/3/1971. Accordingly, the citizenship of the petitioner is declared in her favor. Petitioner is entitled to all the rights and entitlements under the Constitution as may be available to the citizen. Send back the here. Petition allowed. Opinion of the tribunal set aside.
Obliged.
Item 3.
Are we really? It is also noted that DW2 Logosaram Boro had rendered the state evidence in cross-examination, that is, in respect of questions being put by the state of Assam in the Home Department, meaning thereby that it is also the stand of the state of Assam in the Home Department that the petitioner is the daughter of so-and-so. Yes, next one.
May I please, your lordship? My lord, I am for item number 3, my lord. My lord, the order passed by the. Expert. Item number.
You
3.
establish your case here. Sofiur Rahman, who is his father?
Shafiq Qureshi, my lord.
Who is his father?
Latif Qureshi, my lord.
Which page?
My lord, page number 14, your lordship.
Page number 14.
Matter against me was, my lord, ex parte. Page number 14 is a.
This is an ex parte order.
Ex parte, my lord.
Why didn't you go and appear before the tribunal?
My lord, after my brother, there was another case against my brother, my lord. And he has been declared, he's the eldest brother of mine. He has already been declared as not foreigner, Indian.
So that
And
doesn't
the
mean
same-
you will
the
not appear in the tribunal.
No, my lord, same advocate was engaged by my brother for me as well as for he himself, Mr. K. Chetri. My lord, he filed the written statement. I mean, the learned counsel had filed the written statement.
Mr.
In one case,
Counsel, your Sata, is Sata,
Yes, madam.
pay cost, go and appear before the tribunal.
Oblige your worship.
Yes, Mr. Sharma,
Lordship.
let him go and appear before the
Yes,
tribunal
yes, yes.
and get a decision on merit.
Oblige,
Third,
madam.
Mr. E. Satal and counsel for the petitioner also heard in the reward. The petitioner Muhammad Safikul Qureshi had been referred to the foreigners tribunal number
1341, my lord, 1341, 2011.
For referred to the foreigners tribunal number 1, North Lakhimpur, for rendering an opinion as to whether he is a person who entered the state of Assam from the specified territory subsequent to 25/3/1971, resulting in registration of case number LFT case number 1306/2011. Although the petitioner received notice from the tribunal and had initially appeared, but on subsequent date failed to appear before the tribunal without any reasonable and acceptable cause, resulting in the ex parte order dated
My lord, 12/11/2013. my lord.
12/11/2013, being aggrieved, this writ petition is instituted. We do not notice any infirmity in the order dated so and so of the tribunal, inasmuch as the petitioner on his own volition had failed to appear before the tribunal for the further proceedings. But however, for the interest of justice, we demand the matter back to the tribunal for an adjudication on its own merit. Because of the conduct of petitioner to pay a cost of which 5,000 before to be deposited before the DLSA Lakhimpur, and thereupon appeared before the tribunal. The petitioner to appear before the tribunal on
18th April.
My lord,
18th.
I shall be obliged to file my written statement also, my lord.
there you do whatever you do.
Oblige your worship. My lord, that case number is 1341, not 1306.
Case number 1341.
One thing, oblige your lord. Oblige, madam.
Item 4,
Yes, will be appearing. Item 4, who appears? AT Sarkar. You will come. Yes, Mr. Sarkar, your matter is being called. Please respond.
Sorry.
Yes.
So petitioner has been declared illegal migrants, lordship.
Who is the father of the petitioner?
Moyan Ali Sheikh, lordship.
Sorry,
Moyan Ali Sheikh, lordship.
Moyan Ali
Sheikh,
Sheikh. I think.
whose name was appeared in the NRC as well as
Mhm.
1971 records, lordship.
This is item number 4, WBC 1836.
Yes, Lordship.
Yes, lordship. My 1850.
Then,
Wrong.
then why are you appearing? Who appears for item 4?
Oh, it is sick there. No, sorry.
item 5.
We have noticed that on 17/1/2023, none appeared for the petitioner. Today again, none appears. Instead of dismissing the matter for non-prosecution, we wrote a view that for the interest of justice, an amicus is required to be appointed in this petition to assist, to project the case of the petitioner. Accordingly, MS D. Ghosh, learned counsel, is appointed as a amicus, raised to provide the learned amicus with the copies of the pleadings, photocopies of copies of the pleadings. List again.
Item 5,
Moser Ali Sheikh, who is the father?
Moner Ali Sheikh, lordship.
Moner Ali Sheikh, who is the father?
So Moyan Ali Sheikh is my father.
The page number.
Is 30.
Page number
30.
30.
series. This is NRC of my father. And
NRC is not accepted in evidence. Any other document?
page 32, Lordship, 71 total.
32, 71 voters list. Where is Mr. Ali? A. Ali. Please call Mr. Ali. Which document will show that a petitioner is the son of Mayan Ali Sheikh?
Actually, page 26, Lordship, by virtue of one registered sale list, which was.
Page 36.
Sale list. Yes, Lordship, page 26, Lordship. Which was executed in the year on 21/12/1979, Lordship.
No, which document will show that Moser Ali Sheikh is the son of Moner Ali Sheikh?
So by virtue of this sale deed, Lordship, it is reflected. Page 26.
Yes.
Monar Ali Sheikh, first line, Lordship, buyer. Monar Ali Sheikh, son of late Moyan Ali Sheikh.
Okay.
This is the registered sale executed on 21/12/1979, Lordship. And this document was not considered by the learned court below.
No,
learned
no,
tribunal.
this is a land in which village?
Rotia Doha, Lordship,
Hmm.
same village,
Rotia Doha. Where is it written? Rotia Doha.
same next line, Lordship, in the buyer, village, Rotia Doha, PS and Sub Register Office, Golokans, headquarters, Dhubri, District, Goalpara.
Yes, Mr. Sharma.
Yes, Lordship. Before 1971, there is no document, Lordship.
Why do you want?
Lordship.
Why do you want it before 1971? If 1971 this man is present, it is good enough. Boss Mayan Ali আগতে আছে 71. So Mayan Ali protect the here. Where is Ali? Mr. Ali?
He's coming, Lordship.
In the recent voter list, all the voter list used to prepare on 1st January every year, Lordship. In the recent voter list, it is mentioned, the date of preparing voter list, 1/1/1920, 2022-23. Page 79 of the record.
What is this?
That is 71 voter list, Lordship.
70,
Page 79.
no, 79 of the.
Lordship, page 79, 71 voter list, that is exhibit B. The face mark which in red ink, 1, 2 ink is there, red ink is relevant. Page 79.
What we doing? Yes, Mr. Sharma.
लॉटशिप में डायरेक्टली इलेक्शन कमीशन to verify the voter list लॉटशिप
Heard Mr. E.T. Sarral and also for the petitioner, like it, the petitioner Moner, ne?
No.
Moner Ali Sheikh had been referred to the which foreigners tribunal? Referred to the foreigners tribunal number 8 Dhubri for rendering an opinion as to whether he entered the state of Assam's.
May I please, my lord, election commission was not made party, but it was required to make.
Sorry,
Election commission was not made party in this petition lordship. It is required to make.
so
Election commission of India lordship. Not made party lordship in this petition.
where,
Plus, we have-
where is the requirement that they are a necessary party? We can't dismiss a petition for that. Election Commission of India, whether you were a party, you were not a party, remain present in the court invariably. You will know. Resulting in registration of case number FT8/38/GKJ 2016. The opinion to Diriba, opinion that being this winter. The petitioner relies upon the voters list of where is that
Page
Right.
32.
40?
No, 71 voter space 32.
32. The petitioner relies upon the voters list of 1971 of village 130 Paschim Rotia Doha Park 2, police station Golaganj, which contains the name of Mayan Ali Sheikh at serial number 104. The petitioner claims that Mayan Ali Sheikh is his father. To substantiate the claim, the petitioner relies upon a sale deed
Page 26.
dated certificate. Mr. Ali, we are sending it back, but we wanted you to know the authenticity of this voters list. Page 32.
Page 30. Page 30. Page 32.
Page 32 is the English translation, 33 is the vernacular. Why don't you do one thing? Hand over to the court, the entire voters list in this.
I have already spoken, Your Lordship. In this case, I have already written the letter to the CA.
Then why they are not
They
acting?
are not, Lordship, they have already written that the DEOs, concerned DEOs to provide them whatever soft copy they have and what is the stage of, because ECI has, as I was informed, Your Lordship, they have never conducted any such process of scanning the voter list of every.
No,
district
no,
office.
what
So-
we want to know that a document is produced before the court.
Yes, Your Lordship.
Whether it's actually exists or not, how do you know?
Yes, Your Lordship. I have elaborately explained this process. They have asked me.
And especially what has been going on for the last few
Yes.
days, most of the documents it appears are,
Yes, sir. They've asked me on this context of why
Yeah.
court was asking us the entire voter list. So I have.
so that
elaborated this.
we can verify it here
Yes, sir.
itself, and
I have
and a lot of time is saved in
Yes,
this.
yes. For the expeditious disposal of the cases.
Or else, if you don't want, you can connect the court records with that of the election commission so that we can directly verify it from here itself. The
I-
court master can verify it then and there.
Informed to me, Your Lordship, ECI is informed me that since court is directing, they will provide, but they just want some time to verify because they have in fact, even since the deputy commissioner, who was also the coordinating district coordinator of NRC, Your Lordship, at that time, they took an exercise to scan some of the voter list, Your Lordship. They took only the hard copy from us, but they never saw.
No, what we want basically to satisfy ourselves on the authenticity of these voters list, some mechanism where you can verify it then and there.
Expeditiously, Your Lordship.
That's all.
That's what they.
Instead of again issuing notice for this purpose, you will get your instruction, come
Yes,
back.
yes,
A lot of time is wasted.
Yes, sir.
Why can't we directly have access to this information base? That whether this is a valid existing voters list or it is not a valid existing voters list, that's all.
Yeah, because in fact, the recent CEO who has just transferred, like Your Lordship informed yesterday or day before yesterday, he has also forwarded this letter to the ECI Delhi. And they have also asked that they have they instructed him.
So do it immediately.
Yes, yes, yes.
Whatever it is.
I've also forwarded the letter, order passed by this honorable.
Means we don't want the list also. What we need is direct access
To the voter list.
to verify the authenticity of a document produced claiming it to be a voters list. That's all. In
So-
whatever manner you can give that access, you give it.
I'll provide the status, what is there.
And this is required in every case.
Every case.
And how many instruction, how many informations will you bring every day? So a easier option is give direct access to the court system to get it verified.
I'll update the Lordship. Just time, 3 to 4 days time may be given a Lordship.
How much?
3 to 4 days time, I'll give update what is the current status of all the voter lists. If it is provided in the soft
Or
copy,
through the NIC or something, if we can directly connect the court system, that is also good enough. You did not bring anything here.
that will be better option. But
So that with a click of the
but yes, if it is
thing, you
there,
can,
then-
you can get the information.
yes, I'll.
Otherwise, we are accepting whatever document is given to be right.
Because even here also, this is, I have seen a Lordship in the below your Lordship, there is if a Lordship will want, that is a 2 rupees ticket is there also.
Sorry.
In page number 33,
Huh.
this is the potential Lordship is saying.
No, difficulty is everything is there.
Yes.
All these seals and signatures, everything is there.
Whenever I used to verify your Lordship,
Hmm.
they used to verify this, your Lordship. This petition number 172 oblique dated 7/3/2017. Because if a Lordship page 33,
Hmm.
right, the left hand side, right below your Lordship.
Hmm.
That is, they have a 2 rupees ticket, that is your Lordship will see. It's even it is 172 of 7/3/2017.
Hmm.
So they used.
So
to
this is your record,
Yeah,
obviously.
Yes, your Lordship, they verify from this year record was cited, this petition number, and they will verify that whether this was issued, certified copy was issued or not to that person. From there, they verify and they used to inform us whether this is genuine document.
Okay. So what like it, Very good. Sale deed number 4489 dated 21/12/1979. By which Moner Ali Sheikh, son of Mayan Ali Sheikh, resident of village Rotia Doha, had purchased a plot of land. এখানে authentic হওয়া যায় না। নিজে থেকে বলছে যদি এখানে সে দেখতে লিখে দিতে Mr. Sardar. Anybody can do this sale deed. This is your own document, your declaration that you are the son of Bonere. But this is not sufficient. Any person X can go and purchase land anywhere, saying that I am daughter of Y or I am the son of Y. But that will not make that person to be the son of Y. It is your declaration. Any other document.
Any document,
Your
other
school
document,
certificate,
contract
school
is there.
certificate is a good evidence or
Contract certificate is there, but author was not examined. Lord.
Panchayat certificate is what we have seen for the last few days. It is available in the market. So it has lost
What
its
happened that
credibility.
This sale deed was executed in
That
the year
certificate has lost
1979,
its,
Lordship, months before the initiation of proceedings, Lordship. So, Lordship,
which one?
this sale deed, 79 voter list and proceeding started against the petitioner, Lordship, months later than
What is the age of this man, Moner Ali Sheikh, when he purchased the land?
right now, Lordship, 73 years.
73.
Right.
So his name ought to have been in 1971 voters list.
Yes, Lordship, but that was not recorded. His voter name, first time his name was enrolled in the voter list of 77, Lordship.
Why? Why? In 77, this
Yes.
man must be aged about
27 years.
almost
around
30 years.
27 years. Lordship.
So if the father's name is there, the son's name also ought to have been there.
At that time, 21 years, Lordship, voting age was 21 years. Lordship. So
Hmm.
it takes some time, Lordship, to 77.
Doesn't
because-
take time. Very good. Hmm. Primarily general confusion. This one. The mat, in view of the above, matter stand remanded back to the tribunal to arrive at its own conclusion as to whether the petitioner could establish through the sale deed dated 21/12/1979 that he is the son of Mayan Ali Sheikh of village Rotiaraha, whose name in turn appears in the voters list of 1971 of village
Both here.
130 Postim Rotiaraha Part 2. The tribunal to examine the authenticity of the voters list of 1971 of village 130 as well as the authenticity of the sale deed so and so, and further as to whether the sale deed establishes that the petitioner is the son of Mayan Ali Sheikh, whose name appears at serial 104 of the voters list of 1971 of village 130 Postim. Petitioner, any reason order to be passed in favor shall prevail over the opinion to appear on so and so, no pursuit action till the reason order is passed.
His name should be there in 1966 voter list.
Sorry,
His name should be there in 1956 voter list also, Lordship.
the
When prior
state
to
authorities
1971,
are at
yes.
liberty to raise any such objection and also produce any such material as may be advised to oppose the claim of the petitioner before the tribunal.
Item 38,
Mr. Sharma,
Lordship.
instead of raising doubts in a writ proceeding
Yes,
at
yes.
every step, why don't you adduce your own material before the tribunal and establish your case? There is no prohibition under the law that the state is not required to do anything.
Yes, Lordship.
And except for raising doubts at every step, there's nothing under the law that there is no further role of the state to play in these matters.
Please. Iman, okay. Item Iman.
Review. Yes, who appears?
Item. Item number one. Apply.
Item 38,
38 to 38.
Also, I need to go. Very good. Yes, very good. Timing for the RVR Matison. Suddenly 38 visit to somebody when not be ready.
item 39,
In absence of my lord, any linkage, my lord, that opinion has been given. Because my father's mother's name were there.
Sajida Khatun, who is the father?
Puran Ali, my lord.
Page number,
Lordship,
page number.
oh yes. Yes, number, my lord, it is. First of all, my lord, that is page 16, my lord, next up, please. One, page 14 also, my lord, Puran Ali. Page 14. 66 total is Puran Ali. And my lord, page 16 Puran Ali in Annex 2.
Which document will show that Sajida Khatun is the daughter of Puran Ali? Yes, Mr. Das.
That's it. Only urban name is there, madam. And my lord, I have one municipal certificate, domicile certificate. That is my lord there. And my lord,
Who issued that certificate?
what commissioner, my lord?
But this is limited. Use only for address proof.
Yes, yes.
This what commissioner gives the certificate to prove that this lady is residing at Rupnagar.
Hmm.
That's all.
Only to save this skin, he has issued this letter. And from 97 onwards, my lord, she casted harbor. In 2017, the mark is there, 97. But her husband name is here.
How does it establish your case?
There is no linkage, my lord.
Then what to do? Listen. Listen. Mr. Das, if nothing is available, how can we help you?
Everywhere her husband name is there from the 97 onwards.
We understand everywhere husband's
Hmm.
name is there, but how can we help you? How can we pass an order in your favor?
Brother certificate is one school certificate is there, but this does not mean because brother's name and petitioner's name has to be in the one voter list. But that cannot.
No, that will be another aspect, whether he is the brother or not.
Only because of this, my lord,
Who is the mother?
yes, my lord. Mother name is, my lord, in the Labinessa, my lord, Labinessa.
Lavin Nisa is the wife of Nisanuddin, not Quran Ali.
Oh. My lord, sometime may be given, my lord.
The petitioner claims that she is the daughter of Quran Ali, son of Maqbul Hussain, whose name appears at serial 374 of the voters list of 1966 of village 307, Podotika Circle, Balijana, Police Station, Lakhipur, District, Gwalpara. Apart from various materials which show that petitioner is the wife of Ainuddin Sheikh
Yes, ma'am.
of village Darirpar, no further material is available. Mr. H. Das, Land Council of Petitioner, seeks for an adjournment to explore as to whether any further material is available. Adjournment allowed, list after a week. You take back this.
Item 40.
The petitioner refers to a certificate dated 2/12/2019 issued by the Ward Commissioner, Ward number 19, Gwalpara Municipal Board, wherein it is provided that the petitioner is the daughter of late Quran Ali and is an inhabitant of Rupnagar, but again the certificate is itself circumscribed that it issued only for the purpose of address proof of the petitioner. Take it out.
My lord, I mean, in this case, lordship, I need some time, lordship. 1 week time, lordship, at least. One. So now,
Several times, my lord.
no, for a long day, my lord, it was listed, lordship, so.
Earlier also, several, my lord, he was an army officer, my lord.
why do you need time? Sonawalla,
Yes,
I think his name appeared in the newspaper
Yes,
sometime
my
back.
I don't, only one page I showed you, was on page 70.
Page number
70.
7. Some report. Yes.
I told me that this is a page 70 interrogation report of the inquiry. You'll also kindly see my column, middle person 7, 8, 9. Labor, professional labor, you lost. Just I showed you loss. And thereafter, your loss will find. Due to the inquiry, Muhammad Sanawullah last medal could not produce any documents. Then your second interrogation report, your loss will find page 73.
Mr. Chaudhary, why don't you produce what material you have?
Mother?
Why don't you produce whatever material you have?
No, I
Instead of
just,
taking all these technical arguments,
Yeah.
what had happened earlier, we give you the opportunity, produce whatever document you have.
I have put it, I just saw my your lordship just before your lordship, how the interrogation took place, man.
Mr. Chaudhary,
Yes.
forget about what had happened in the past.
Page 60, my lord, is HSL certificate, your lordship.
We are giving you the opportunity to
Yes.
discharge your burden under section 9.
Right.
Please produce.
I discharge tribunal did not believe, man. So we are before lordship, man.
Therefore, we are asking you to please discharge the burden once again. Show
Page-
us whatever document you have.
Page 93, your lordship.
93.
My HSL certificate. HSL. Page 93.
Yes,
94
this
is
is
the,
a certificate of 85.
that, but my date, your lord, can you see the examination map? Date of birth is written there, man, 1967. Date of birth is there.
How does it establish your citizenship?
No, there might even 67, then you're looking at my appointment letter, page 97, appointment letter. Appointment letter, one. 97. Discharge, discharge letter, madam. Page 97. Discharge, it is a discharge, he was, date of enrollment is there, date of birth is there, date of discharge is there.
Everything is there,
Everything.
but how does it establish your citizenship? We are not, no one is doubting your date of birth.
Right.
Establish your citizenship. Tell us who is the father of this man
Page 81.
and that the father is a citizen.
Yes, that is there, man.
Please show.
Page 81.
Page 81.
My father's name is there, man. 1966, Buddha.
Who is the father?
Father is Muhammad Ali.
Muhammad Ali of village
Of-
Polo Hikas.
Yes. Yes.
Now, which
But-
document will show that you are the son of Muhammad Ali
Right.
of village Polo Hikas?
Page number 82 is the vernacular.
Sorry, I understand. Which document will show that a petitioner is the son of Muhammad Ali
Then madam,
of village Polo Hikas?
my school certificate, everything is there, madam. My father's name is there. madam.
Page number.
Page 107, you're looking at 107. 107.
107 is the office of the deputy commissioner.
Yes, Bhutal list, madam. My father's name is there. madam. My name along with my father's name is there. 2005 Bhutal list.
Yes, Mr. Sharma. Where are the in-between voters list? Where are the in-between voters list from 1966 to 2005?
89.
89. All over the world.
1989, but the name was wrongly written.
Hmm. That is, I have written my, in my WS here, Sujawullah, instead of Sanawullah, written Sujawullah.
It's only which page?
Page 89. 89, vernacular is page 90, madam, your worship. Serial number 117. 117 is page, your worship, 90.
Page 91.
The vernacular, you will that will be better, my page 99, 90, my. 90 serial number
117. It is written Surjaullah instead of Sanaullah. That I have clarified in my WS also.
Mr. Ali,
Yes, sir.
check up from the continuous voters list.
Yes, sir.
Because 2005, Sanaullah is the son of Muhammad Ali of village Kolohikas.
Yes, sir.
And Muhammad Ali, 1966, his name appears village Kolohikas.
Similar.
Ah. So see the complete in between voters.
Yes,
list.
sir.
If it is there, that is
Definitely,
his
yes,
case is proved.
Yes.
The Election Commission of India to produce the complete voters list from 1966 to 2005 of village Kolohikas to enable the court to examine as to whether the petitioner Sonawala is the son of Muhammad Ali, whose name appears at serial 27 of the voters list of 1966 of village Kolohikas. So these are just
1 week time. will be there.
1 week,
One.
list next week. I think, Mr. Chaudhary, this is an easy way for you,
That is
instead
there,
of going
my
to all,
only part is I for your lordship.
all technical arguments.
I only because how this thing is happening, man. That is why just.
But that will not establish your citizenship.
Madam, question.
Mr.
Once-
Chaudhary,
Yes, ma'am.
what are these proceedings? These are proceedings under Section 9 of the Foreigners Act, where the proceedee is required to discharge the burden to prove that he is a citizen.
Yes.
So from that point of view, even if the reference order is wrong to some extent, that will not make the person a citizen of India. That will at the best require the authorities to re-refer you once again. So discharge your burden under Section 9. And how can you establish if your name appears along with your father in the same village? That's a good document.
So put the exhibition.
So why don't you confine your arguments to that instead of,
Well, that's true, madam, but your
Taking
motion is to see
the-
how things are happening, but that's why I just.
we are not here for a
And
second.
then officer, it might was, he was taken to custody also, man. He was in detention camp.
Mr. Chaudhary, for that you filed a writ petition claiming damages against the government.
And that
But
might not-
this is a proceeding only to determine whether you are a citizen or not. We go by the law.
Anyhow, madam, but anyhow, so your date might not.
Next week, your fixed date. Mr. Ali, produce the complete voters list
Yes,
so that we can examine whether it is.
Yes, I will complete.
23rd March.
23rd March. Obliged to.
Item 41.
Who is this? Hmm. When the matter was listed on 2/2/2023, Mr. A. Motin, learned counsel who appeared for the review petitioner, had made a statement that the petitioner Jamaluddin had taken back the brief from him. On the said date, otherwise none appeared for the petitioner, and the matter was adjourned with the observation that on the subsequent date, if none appears, adverse order shall follow. Today, when the matter is called none appears, dismissed for non-prosecution.
Item 42.
Will be dismissed for- I might have to review it. It's not very tricky.
Please, Lordship, for time being, Lordship, my senior late court number 3, Lordship.
43.
42, who appeared just now, item 42. We are not going to adjourn this matter only for the time being. It will be called again. Yes, Mr. Mulundar.
Lordship, impugn judgment, Lordship, at page 30, order. Okay, learned, and then finding at page 40.
Uh, Who is the father of Ahmed Ali?
His father is one Abdul Rahman Lordship and grandfather Rahmat Ali. Their name appeared in the voter list. Lordship,
Page number?
Lordship. Lordship, it is find it is type copy Lordship, page 32, annexure D,
Page 32.
Lordship.
Who is the father?
Lordship, his father is serial number Lordship 179 A Rahman and grandfather Rahmat. And his name appeared is the serial number 181 Ahmed Rahman. And the vernacular page Lordship page 30. And another Lordship, I have annexed one Jamabundi copy Lordship. Kindly have a look. That is at page 41, annexure is
Page number?
41.
41.
Abdul Rahman, son of Rahmat, his name was recorded in the record of life Lordship. And vernacular Lordship, it is at page 40. His father's name appeared in the record of life Lordship. These are the two linked documents we have executed before the court.
Rahman to the citizen. Yes, anything more?
My friend. Lordship, and his grandfather name also appeared in the voters list of 1966.
Page number?
Lordship. Lordship, kindly come to page 30. Electoral roll of 1966. Rahmat Ali. Lordship, it is serial number 192. And his father, Abdul Rahman.
Yes, we read it.
And Lordship, kindly have a look at the finding of the learned.
Finding, we are not interested. You discharge your burden under section 9.
So,
Do you feel that you have already discharged your burden?
I
Or you want to say something more?
Lordship, I have exhibited a document
No, we
prior
have-
to 1971. One
Mr. Mojumdar, we have heard everything you said. We have also perused the materials you have indicated. Do you feel satisfied that you have submitted everything, or you want to say something more?
Lordship, one. Lordship, it is true that there is some document is also not in between 1980 and 19.
No, we have not asked you that question. Do you feel satisfied that you have made your complete argument submission, or you want to say something more?
If your lordship satisfied, then this is enough.
We can be
If not,
satisfied.
lordship,
we can
I
be-
leave it-
we can
leave
be
it to
satis-
your lordship. If
we-
your lordship not satisfied.
We
then-
can, no, we are not required to tell you our. You can be satisfied either way, either in your favor or in his favor, both ways. Of course, we are satisfied in one way. We are just asking you, do you want to say something more, or you feel that your submission is complete?
And lordship, we have also exhibited Gaupula certificate.
Dismiss koro, right? Better go, Mangu is- Point hai there, bhai. Where is the Gampura certificate?
Lordship, that is at page 53.
50,
53,
53.
lordship.
Yes. We dismiss. That's why I'm asking you, do you want to say something more?
Otherwise, lordship may allow us to exhibit some more document.
What document you want to
Uh,
exhibit? You can exhibit anything in this world. You are free to do so. No figure, but what document?
Voter list
Voter list of?
of lordship, their period lordship, that is.
We don't want that for the time being.
Otherwise, this much. Nice.
But your grandfather, it is a different village, page
Lordship.
30.
It is lordship.
Mm. Page 30 is of village Bihia and page 32 is of village Rajbhoral.
Lordship, it is very lordship and the neighboring village.
What material do we have before the court to accept that it is neighboring village? And what material do we have to understand that Rahmat of page 32 and the Rahmat of page 30, they are the same person? They may be different person also.
Lordship.
That's why we asked you whether your submission is complete or you want to say something more.
Lordship, there is a sale date that we have also that
Page number.
and that is at page 37, Lordship. It is executed in the year 1976.
That's what we're asking. How do you know that this Rahmat Ali, who can be traced to village Rajbhoral, and the Rahmat Ali, who can be traced to village Bihia, they are the same person? Merely because the name is same does not mean the person is also same.
We have stated, Lordship,
Son of Afsar. Rahmat is son of Afsar.
Lordship, we have stated before the tribunal in our Lordship that they are the one and the same person. Only evidence to that extent, relating
That
to
is-
same
status-
quality, same place.
Stating is not evidence. Stating is a statement. So.
Lordship, otherwise we may be given 10 days time. If there is any such a material.
Mr. L.R. Mojumdar,
Lordship.
why do you want the court also to act as an amicus for the litigants? Why do you always need the aid of the court help to get orders in your favor?
Lordship, as on
Why can't you use due diligence? Carefully look into all the materials we have referred till now.
actually, there is some problem, Lordship. I am not
The problem
actually
is you are not.
not the conducting lawyer. That's why I am not fully.
Then that is
actually,
also
I
not an
shall-
answer. That is also not an answer. This 6-7-year-old matter. Every council is a learned council. There is nothing called conducting council and non-conducting council. You are a man of wide experience, very learned. Read carefully, the answer is there in your favor somewhere. We are taking it up after some time.
Lordship.
Read the
Alright.
materials you have referred to the court till now. There is an answer in your favor.
Obliged.
But you can't take the aid of, convert the court to an amicus
Right.
and require to help the litigants in every case. Find out.
Item 44.
Yes, Mr. Chigdar.
May please, your Lordship. My lord, here in this case, my lord, the father of the petitioner,
Abdul
Abdul.
Mannab Ali. Who is the father?
my lord, Atabuddin Sheikh, Lordship will find at page 51,
Page 31,
51.
51.
Atabuddin Sheikh, mother's name Momena, village Sardarpar, all along Sardarpar. Sardarpar. 70 Butali.
Page number 51.
51,
Yes.
52 is
Sardar
the
Para, right.
70 Butali.
And who is the father? Atabuddin.
Atabuddin.
And which material will show that you are the son of Atabuddin?
My lord, page 57. my lord.
Seven.
Vernacular is also there, page 58. I am with my parents, my lord.
Petitioner is Abdul Mannab. Abdul Mannab.
My lord, there may be some variation of here and there, minor variation,
No minor variation. There are major variations.
my lord. Abdul Munaf,
Mr. Sigdar, minor variations we are ready to ignore, but there is a major variation.
Abdul Munaf, my lord.
No.
Atabuddin Sheikh,
There is no difficulty with Abdul Mannab. Difficulty is you claim Atabuddin Sheikh of 65 voters list to be the father.
my lord.
That Atabuddin is son of Raja Mahmud Sheikh,
Raj Mahmud Sheikh,
and village is Sardarpara.
my lord. Here is also.
Whereas
Sardar-
page 57, it is, name of the village is not indicated. And Atabuddin Sheikh is son of Khentepa
Khentepa Sheikh, my lord.
and not Raja Mahmud.
My lord, kindly have a look at the other Bhutta list. Somewhere, my lord, Raj Mahmud, somewhere, my lord, Khentepa Sheikh. That is, Khentepa is the grandfather's nickname, my lord. So That way, my lord, in some voter list, Karnataka is there.
So where is the name of the village in
Well-
page 57?
All along Sardar Para.
Understand, where is the name of the village? At page
My lord,
57.
lots you will find in Bharlakoda, page 58,
Hmm. Gaunam,
Sardar Para,
sorry,
page
Where-
58, my lord.
where is the name Sardar Para?
My lord, lots you will find in top. Ongho number 2, 24 number Sardar Para, page 58, my lord.
Page 58 only I am referring. Where is the word Sardar Para?
Annexer 11, my lord, page 58, my lord.
Mr. Sigdar, I am looking at page 58 itself, but where is the name of the,
My lord,
okay, Sardar Para.
my lord, village
Yes,
here,
yes,
my
you're
lord,
right.
written as
You're
part.
right. It is Sardar Para. Khali Khentopa Holder.
Sardar Para.
Which are the other voters list? One
My
showing Khentopa, others showing
My lord,
Atabuddin.
Lordship you will find, my lord, 65, 70 have Lordship has seen, my lord. Then, my lord, in 97, voter list, page 54,
This is of which village?
is also Sardar Para, my lord. Atabuddin Singh, Kantapur Singh.
Yes, Mr. Sharma.
Lordship. Regarding name. It is Lordship Atabuddin Sheikh, son of Khemtepa Sheikh. And Atabuddin Sheikh, son of Lordship.
Son of Raj Mahmud.
Yes, Lordship. Rasmur. They cannot be same in one person, Lordship. And Lordship. Although village is same Lordship. Persons may be different Lordship. And my lord. A petitioner document which is related by the petitioner Lordship. That should be appreciated as a whole Lordship.
Appreciated as a.
As a whole,
Yes.
not partly Lordship.
Who is looking at it partly?
Lordship, in which part, in his favor, he.
Sorry?
In which part, in his favor, petitioners proceed his favor.
No, no,
Lordship.
that is a good legal argument,
Yes, Lord.
but who is looking at the documents in a part manner?
Okay.
The petitioner or the court?
Petitioner Lordship.
No one is looking at any part manner. Everybody is looking at the documents as a whole only. Heard Mr. A.R. Sigdar and counsel for. Yeah, that's all. Cannot be so much of a coincidence. Heard Mr. A.R. Sigdal and counsel for the petitioner. Respondents. The petitioner Abdul Mannab Ali alias Abdul Mannas alias Abdul Hanif. Why you become Hanif all of a
My lord,
sudden?
notice is issued in the name of Hanif Ali,
Where is the
Hanif-
notice?
but he is not Hanif. My lord.
No, where is the notice? Let us see. Where is the notice?
Lordship will find the annexer 1 and
Notice you find annexure,
Abdul Hanif, my lord.
page number.
Page 21, my lord. Bharnakuda. My lord, one interesting fact is here in this case, my lord.
What interest?
My lord, tribunal has disbelieved the documents because the notice was issued Hanif Ali, so it cannot be on Abdul Mannab.
Understand.
And tribunal also hold a view that the
Mr. Sharma,
My lord.
if you proceed against Abdul Hanif
Yes, Lordship.
and you serve the notice on Abdul Manaf
Yes, Lordship.
and then declare Abdul Manaf to be a foreigner, is it tenable?
I think it is not a neighbor.
Mhm. And why you don't declare him to be a foreigner? Because he could not prove documents regarding Hanif. Imagine a situation. Today, suppose we are the tribunal. We are required to proceed against Mr. Sikdar.
Yes, sir.
We issued a notice to Mr. Sharma. Okay. Mr. Sharma comes before the tribunal, proves all the document of Mr. Sikdar. Then the tribunal will hold it that Mr. Sharma could not prove his own documents, so you are a foreigner. And that declaration will be applicable to Mr. Sikdar. Is it possible?
It's not a neighbor.
My lord, the record says that
How it can happen? How, if you issue notice to a different person, but the notice will be
But
in the
others
name
name
of a
is
different
same.
person, but serve the notice on another person.
the name is-
That person proves his authenticity. Then you come and conclude, no, you could not prove in the name of the person in the notice. So the other person is a foreigner now. It's a absolute.
It's not tenable lordship, but here lordship, he accept the notice as well as lordship.
Should
Others name is same
we,
lordship.
should we impose cost on the tribunal
Lordship.
for harassing this man? I think the time has come to do that. Why will the tribunal not apply its own mind, reasonable mind, and proceed in these matters? And under what circumstance a man can prove that he is somebody else? So now Abdul Manaf, who had been served with the notice in the name of Abdul Hanif, will have to prove before the tribunal that he is Hanif and that Hanif is a citizen. How can you prove it? If you actually serve on Hanif, Hanif may be able to prove it, but how Manaf can prove on behalf of Hanif? And because he could not prove on behalf of Hanif, so therefore Manaf becomes a foreigner. Is it not absurd? Heard Mr. Dia Sikdar, that was a big example. The petitioner Abdul Manaf, Abdul Manaf Ali, alias Abdul Manas, had been noticed by the Foreigners Tribunal number 2, Golpara. As per the notice in FT bracket 2117/K/16, it is noticed that the said notice had been issued in the name of Muhammad Abdul Hanif, but it was served on the petitioner Abdul Manaf Ali. When Abdul Manaf Ali appeared before the tribunal and through his materials sought to discharge the burden that he is a citizen of India, the tribunal renders the opinion dated. What is the date of the opinion?
My lord, at page 45, my lord, judgment dated 30/9/2016,
Page 45.
45. Annexure 5.
Where is the finding that you could not prove as Hanif?
My lord, the tribunal recorded very interesting finding, my lord.
Where is it? Which paragraph, which page?
My lord, page 48, lordship will have a look at paragraph 8 and 9, both are interesting, my lord. 8 and 9, page 49, my lord. 14, page 9, paragraph 9, my lord. In paragraph 8, my lord says that LBO report is also Hanif. ERO report also Hanif. That is not correct, my lord. I have gone through the records, my lord.
It is also
The record says that, my lord, LBO has
page 49. Trying to mislead the court by refusing documents which are not genuinely his own. And if a document not.
My lord, record says that, my lord, LBO report is correctly made as Abdul Manaf, my lord. But the ERO and the border police are, my lord, referred as Abdul Hanif. So basis,
This- Mr. Sharma, why the tribunal concludes that the voters list of 2005 is not reliable? বলো, last sentence, বলো। Actual and appeared before a tribunal and that the petitioner by producing the documents related to Abdul Manaf Ali had tried to mislead the tribunal by producing documents which are not genuinely his own. It one inverted comma did one tried to mislead it wrong idea page 49 of full stop. The tribunal thereupon arrives at a conclusion that the notice was served in the name of Abdul Hanif. As per the voters list of 1977 of Sardar Para. But however, in the voters list of 2005 produced by the petitioner showing him as a voter, the name appeared as Abdul Manaf Ali. Full stop. If the tribunal had issued the notice in the name of Abdul Hanif, but served it on Abdul Manaf Ali, and when Abdul Manaf Ali appears before the tribunal by producing documents related to Abdul Manaf Ali to discharge the burden that Abdul Manaf Ali is a citizen of India, it would be absurd on the part of the tribunal to dismiss the claim by arriving at a conclusion that the petitioner Abdul Manaf Ali is trying to mislead the tribunal by producing documents which are not genuinely his own, as because the notice was served to Abdul Hanif. Because of the aforesaid discrepancy, the aforesaid unacceptabilities of law, both the notice did in FT 2117/K/16 in the name of Abdul Hanif, as well as the opinion rendered by the tribunal dated so and so after serving notice on the petitioner Abdul Manaf Ali are both set aside. If the tribunal is of the view that Abdul Manaf Ali, son of Atabuddin Sheikh of Sardar Para, is required to be proceeded against, the tribunal may issue appropriate notice as per the name of the proceeding and thereafter proceed against the petitioner if so advised. Send back the LCR, petition allowed as indicated above.
well, LBO report says that Abdul Manaf, but ERO report says that,
Whatever it is.
yes,
So if Manaf Ali is to be proceeded, they'll issue notice to Manaf,
Right,
he'll
right.
prove his own case,
absolutely.
not in the name
My
of
lord,
somebody
yes.
else.
Deeply obliged, Lord.
Item 45.
In this case, my lord,
Apash Ali, who is the father?
the father is Abdul Aziz Sheikh.
Abdul Aziz Sheikh. Which page?
You also kindly see page 18,
Page 18.
1966 voter list.
Abdul Aziz Sheikh, son of Keram.
Karam is my father. No,
No,
grandfather,
no, Abdul Aziz is the father. Keram is must be grandfather.
grandfather, my lord.
Village 155,
Yes,
Airang Jongla.
Airang
Airang
Jongla,
Jongla, part 2, Golpara,
part 3.
yes, Dhubri.
Then in 70 also,
Okay, now which document will show that you are the son of Abdul Aziz Sheikh of Keram?
grandfather, what happened, my lord? Thereafter
Shifted.
we shifted. Father also shifted in village Tokresora. You will also kindly see an exhibit
Page-
page
page
20,
number?
28.
Page 28.
Yeah.
28,
28. 20 is the vernacular,
28,
20,
20.
28, the vernacular. Pasim Tokresora.
So now this village is West Tukreshwara.
Tokresora. It is the voter list of 1989. And my name also appeared in the voter list of 1989, it's different house, madam. It is exhibit 6, page 21A.
Which year the shifting took place?
They shifted around the year of 1980.
1980.
But the original land is there. Original land is there. And thereafter, that land, his uncle.
From which year the name started appearing in Tukreshwara?
89 first time.
89.
Yes, first time.
After 89, your names, was your name deleted in Airang Jongla?
Oh, no, I am.
Or you are having names in both the lists?
No, no, no. My first time, my name appeared in the place. I don't know. My name
No,
is
that
not
is
there.
okay. The name of your father, Abdul
No,
Aziz,
not there.
from 89 onwards, it's not there.
Not there.
Okay.
Because 89.
The respondents in the election commission to produce the upward and downward voters list of village 155 Airang Jongla part 2 and West Tukreshwara to enable the court to examine as to whether in a circumstance when the alleged shifting took place sometime in the year 1980,
1980.
the name of the father of the petitioner, Abdul Aziz, continued to exist in the voters list of Airang Jongla Part 2 after the shifting, and whether the name of Abdul Aziz Sheikh appeared in the voters list of Tukreshwara prior to the shifting. List after a week for production of the voters lists. Complete voters list of both the thing.
Item 46.
Mr. Sharma, inform Mr. Ali about this order.
List after.
After 1 week?
I also try whether in the
See, yeah.
75, 77 voter list is there.
If you can
I-
show that the name got deleted on the day of the shifting or immediately thereafter in the original village and included in the new village, and then in the new village, the same name did not appear earlier,
Yes.
that is a good material to prove the shifting.
Maybe 75, 77, they are not there, but it may be there, their name.
With little variation, we accept it, but at least. But if you find that this Abdul Aziz continued prior to shifting in this one, other Abdul Aziz continued to
Yes, yes.
exist in the old one, that means both are two different persons.
46.
46 ways. If you-
May I please go? Hello, in this case, minute, a
Tokmina
reference,
Ahmed, who is the
Yes.
father?
before going to that minute, I would like to argue one thing. Minute. A reference was forwarded by the superintendent of police before the tribunal asking for a decision whether the proceeding is an illegal migrant or not. Now, your lordship kindly see from the record, Miller, page 9 and 8.
Mr. Counsel, why the attempt is always to go into technicalities of law? Technicalities of law will not lead to a conclusion for a declaration that you are a citizen of India.
Yes.
Technicalities of law may be an hindrance for the time being. so that you'll be again referred by following the proper procedure.
Yes.
It's better for you to accept our offer. You produce any material to discharge a burden under section 9. If you can, you take the order here itself.
Only the thing, my lord, in that
So who is the
court, my
father
lord,
of
the
the
police has
father of the,
verified and found that I am an Indian citizen. Even then, my lord,
but that also will not, that will at least render the reference to be bad. They can again refer you.
Yes.
So if you are a genuine Indian citizen, show it. Takmina Ahmed. Who is the father of Takmina
Kashim
Ahmed?
Ali. There's some
Page number?
discrepancies in the name of her father. I
Page
think.
number,
16, annexure 3,
sorry,
16.
16. That's a better approach. Interference here and there could be over. Kashim Ali,
Kashim Ali.
son of Rahmat, village.
Village, my lord, Ambari.
Mokora hata hota hai isan ko. Okay. Which village? Village is Ambari.
Ambari.
Ah.
Under Gwalpara.
Which document will show that the petitioner is the daughter of Kashim Ali of Ambari?
Yes, my lord. There is a cabin number, my lord.
Page number
Page number 18, annexure 4.
18. Okay.
Takmina Khatun, father's name, Abul Kashim.
Coiner Nam. Muslim Tasminda Khatun, Abdul Kashim Ambari. Mr. Sharma, go back, examine this. Heard Mr. I. Rafiq, learned counsel for the petitioner. Also heard Sobari Didibo. The petitioner Takmina Ahmed alias Tahmina Khatun alias Takmina Ahmed. Why so many names?
After marriage, my lord, this
Had been referred to the Foreigners Tribunal number
4 number.
sorry,
4,
4 of which place?
Gwalpara.
For example, for Gwalpara, for rendering an opinion as to whether she is the person who had entered the state of Assam from the specified territory subsequent to 25/3/1971, resulting in registration of FT case number
FT case name, my lord. Four 26,
426
stroke
stroke
2016.
2016, an opinion dated
31, 2017.
31/2017 had been rendered declaring the petitioner to be not a citizen of India. Being aggrieved, this petition is instituted. The petitioner relies upon the voters list of (1970) of village 306 Ambari, police station Lakhimpur or Lakhipur?
It's Lokhipur.
No, Golpara, there is no
Lakhipur.
Lakhimpur, there is Lakhipur.
Typical mistake. Lokhipur.
Police station Lakhipur in the district Gwalpara, which contains the name of Kashim Ali, son of Rahmat Ali at serial 384. The petitioner also refers to a Kabin Nama, which is annexed as Annexure 4, page 19 to the writ petition, wherein the name of the bride is shown to be Tasmina Khatun, daughter of Abdul Kashim. No, this is Abul Kashim. This
Yes.
is not Kashim Ali.
No, not Kashim Ali.
No,
The discrepancy is there, my lord.
no, you know, this
Village is same.
Hmm,
Village is same, my lord. Ambari,
maybe. Abul Qasim of village Ambari in the Gwalpara district. Petitioner to provide any further material which may indicate that Abul Qasim of Annexure 4, page 19, Kabin Nama, and Qasim Ali, son of Rahmat Ali of the voters list of 1970 of village Ambari are one and the same person. List after a week. Very morning.
Time being item 1.
May I please? My lord, the impugned judgment your lordship will find at page 106.
Timing কেউ করেছিল? Yes, please. Dilwar alias Muhammad Dilwar Hussain. Who is the father?
Father, my lord, Jamir Uddin, alias Jamir Ali.
Petitioner has 3 alias. The father has 2 alias.
My lord,
Anyway, which page number?
my lord, the voter list lordship will find at page, my lord, 95.
95.
Four brothers, my lord, in a different 4 cases, my lord, common judgment has been passed. Page
Father
90,
is Jamir Ali,
yes,
son of
son of Kutimia.
Kuti Mia. And this petitioner is Dilwar Hussain.
Dilwar, Anwar,
Okay, fine.
Asad.
Now, how do you know that Jamir Ali is a citizen?
yes, lordship will find first, my lord, voter list of my lord 1966.
Page number.
That your lordship will find at page 81. My lord, Sikandar Ali, the my lord, a great grandfather.
Great grandfather.
Yes.
Okay.
Then my lord, page 83,
Just a minute. Great grandfather in the year 1966.
66.
And the great grandson is before the court now.
My lord,
What is the age of the petitioner?
age of this petitioner, my lord. Asana? Is different lane. But as per voter list, my lord,
No, you must have stated in the affidavit at least.
I'm right.
Petition.
yes, age was not required, my lord. Page 95 say, my lord,
In the affidavit,
2014.
age is not required, recorded.
Yes,
Then
page
it-
18 lordship, in affidavit it was mentioned 31 years.
31 years.
Filing of the
So, Mr. Mondol, in 2017, Dilwar is 31 years.
My lord.
So today is 2023.
23,
So he must have been born around 1992.
92.
From 1996 to 1992,
Right.
that is within a period of 26 years,
Right.
can 4 generations exist? That means every generation must be born.
Right.
So 26 divided by 4 will be approximately 7, say. So every 7 years, one new generation is coming up. So one 7-year-old father will have a son. Then and that son will be, when he will be 7 years old, he will have his own son. Then that son, when he will be 7 years old, will have his further son to have the 4th generation. Is it possible?
That I cannot say, my lord.
Then who can say? So prima facie, it appears to be something unacceptable. Either this person is not the 4th generation
My lord,
of Sikandar Ali of 1966,
my lord.
or somebody else has have been brought in
Lord,
to be called the grandfather, great grandfather?
That aspect, my lord, I have to explore.
You please explore.
Yes.
What is the next one?
Yes, next, 66 lordship, and see, then, my lord,
Village.
page
Sorry,
83.
sorry.
71, my lord,
And then all the villages are also different.
Sikandar, same village, my lord.
Seven,
Uttur
page, after
Tamil.
81, page 71,
Page 83, my lord.
83. NRC is not acceptable.
Yeah, no, it is Buddha list, Buddha year 1971.
Hmm.
Lord,
No, page 83 is some NRC.
yes. Then, my lord, page 85, lordship will find
85.
Buddha list 70, my lord. A Rohim, my lord, uncle, and A Zolil uncle, son of Sikandar. Page 85,
They are son of Sikandar.
Sikandar.
Now, who is your grandfather now?
My grandfather Kutimia. Now,
Kutimia.
Kutimia was suffering, my lord, suffering from mentally, my lord. Because of that, his Buddha, his name was not recorded in the Buddha list, as have been reflected in the WS and the evidence.
But he is mentally suffering, therefore name is not in the voters list.
Yes,
But he has his own family and everything.
my lord,
He
everything.
is otherwise leading a very normal life.
My lord, since he's mentally not, my lord, fit person, my lord.
Understand, mentally is not fit to be in the voters list,
Yes,
but otherwise mentally fit to have his family till the third generation.
yes, family is there, my lord. But because
Very
of that, my lord, his name was not recorded, my lord. He went so here and there, my lord.
But a family remained.
Family are there.
And this man went here and there.
And sometime he lived at Karbi Anglong also. There is a document of one of his son was along with him.
Okay, fine.
Then, my lord,
Further-
page, my lord, 87, lordship will find Buddha list of 1977. Now, this time, my lord, his name has been recorded at the age of 47 years.
So
Yes,
now, from village Samorali
Yes,
in Nagaon district, he goes to village Uttar Samorali, same village,
page 80, same village,
1977.
Kutimia. Then, my lord, Zomiruddin, my lord, father of the petitioner, alias Zomir Ali. Next time, my lord, Zomir Ali, lordship will find. And Amir Ali and Tomir Ali, all are son of my lord,
So you are now son of Jamir Uddin.
Zomir.
What happened to Jalil? Jalil and Rahim?
Jalil,
What happened to Jalil and Rahim?
Jalil and
Rahim?
Rahim.
Because along with Sikandar in
Yes.
66, also appeared the name of A. Rahim and A. Jalil, both are son of Sikandar.
Yes,
70 also Rahim and Jalil name appear.
yes, 70.
In 77, Kutubia, son of Sikandar appears, but what happened to Rahim and Jalil?
Yes, their name is not figured, my lord.
The petitioner to produce any voters list of village Uttar Samorali, PS Murajar district Nagaon, which may contain the name of A. Rahim, son of Sikandar, and A. Jalil, son of Sikandar, along with that of Kutimia, son of Sikandar.
My lord, there are
Suppose the 77 along with Kutimia, Jalil would have been there, maybe we would have accepted it. You produce any document?
and after that, my lord, there is shifting.
There is no shifting. Till 77, it is same village, Uttal Samorali.
Next, my lord, page 89.
89, we'll deal with later on.
Yes.
But if you can establish from 77, that Kutimia and that A. Jalil and A. Rahim,
My lord,
they are all sons of Sikandar
Sikandar.
of the same village. We'll examine your case further beyond that. Just after a week.
Time being item 38.
Section of Manhattan matters. Quickly, somebody, the judicial or the DOJ.
Oblacios.
আর হেলিকে মাত্র রেজিস্টার কার ইনচার্জ এটা বসছে কেন ইনচার্জ Yes, sir.
Lordship.
Review.
Review, basically, the writ petition was rejected because no.
Yes, please.
Is page number 22 and last. There is no link established between the grandparents and father of the petitioner. Being no voter list, the name of the father of the petitioner with the grandparents. It was the reason. So why the petition of the petitioner was rejected. Lordship. Kindly come to the page 48. 48. Forty-eight is the copy of Jamabandi. Abdul Jalil is the father of the petitioner. And Taleb Ali is the grandfather of the petitioner. Thereafter, Lordship, page 50 is sale deed. Here, page number 50, Annex L. The father, grandfather of the
Which document will show that Abdul Jalil is a citizen of India?
Abdul Jalil, he had casted vote in the year of Exhibit D, page number 36. In the voter list. 1997, he casted vote. And his grandfather has casted vote in the year of 1966 and 70.
Page number.
Page number 34 and 32. 32 is the voter list of 1966.
Taleb Ali. Mhm. 70 from village government. But 1970 is a different village.
1970 is a different village.
Bangalpara.
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 Subsequently,
66 is also Bangalpara.
Bangalpara,
But the
1970.
school certificate and Jamabandi, it's of village,
Made Kaurbaha.
News Kaurbaha.
Kaurbaha. It subsequently shifted by purchasing plot of land at Kaurbaha.
What evidence you have that that is
Sold it.
shifting? Sale deed is a evidence that you purchased land in Korbaha. One Jalil purchased land in Korbaha. Where is the evidence that you had shifted? That in other words, that Taleb of the Jamabandi and Taleb of 66 voters list, they are same person. The petitioner to produce any relevant materials which may indicate that Taleb Ali referred in the Jamabandi at Annexure J, page 48, and Taleb Ali referred in the voters list of 1966 of village Bangalpara, Aru Jamabandi to Dibo of village Niz Kaurbaha are one and the same person. Based after 2 weeks.
Time being 42.
Well, in this case, Lordship, the learned tribunal hold that although the petitioner is established his link with his father,
Sorry,
but
Rehana Bibi, who's the father?
father Lordship, my father's name is Abdul Karim Sheikh and Elias Lordship Abdul Karim Boss.
Page number,
Abdul Karim Sheikh Lordship,
page number
Lordship, in the voter list of 1960, page 18.
18.
Madam. 19 is the Vanagala.
Abdul Karim Sheikh said,
Why?
what you did.
Muslim Beva is my grandmother. And
Which document will show that the petitioner Rehana is daughter of Abdul Karim?
my lord. Lordship, I have proof, Lordship, we exhibited on school certificate,
Page
page
number
Lordship 44.
44.
That document Lordship has been proved, that is page 40. By the
Page
headmaster.
44.
44. 44 is the certificate and 40 is the evidence of the headmaster.
Where is the evidence of the headmaster?
My lord, page 44.
Two homes to register. Or authentic questions crossing you were into is 40. It is the English for them.
My lord, Page 46 is the division register.
Exhibit two, exhibit two. Financial maintain no করেনি। এখন যে দিলে তখন তারপর হাতে বের লিখি exhibit কোড আছে exhibit কোড করতাম ফার্স্ট হয়ে পড়ছে ফুল অফ রেজিস্টার exhibit টু Xerox copy of the relevant school admission register as exhibit two. Let me find this camera. Hold on, here we go. Now this. Yes, Mr. Sharma. Yeah, okay. Portfolio, exhibition portfolio.
In page 59, lordship, it was discussed, lordship, regarding school certificate, lordship.
Mr. Khan, from where did you get this page 46?
Page 46, Lordship.
From where did you get it?
Lordship, that was produced by the headmaster.
Understand from
Exhibit 2, Lordship.
where did you get it?
Exhibit 2.
Understand it is exhibit 2. From where did you get the copy of it?
This is from the tribunal, Lordship. Certificate copy, Lordship.
See if it is here in the records.
I have the certificate.
Understand, you have annexed. See if the same document is there in the
Yes.
records. You will agree. You will agree that the record is not so important. No, sir. Mhm. If somebody is wrongly declared citizen for your negligence, it's not so easy.
Yes.
Abdul Box Korsa. Korsa that is on now. So Abdul Karim Box. Korsa that is. Certificate from the TKBC, certificate for instance. Where is that voter list? Refer this
18,
down.
18, 180.
1 is
19 is the Bhanet launch.
page 18,
19 is occupancy.
19. এখানে তো কত টাকা please? 66 Yes, Mr. Sharma. Page 19.
Yes.
Abdul Karim Sheikh.
Malak, sometime your lordship will get Abdul Karim box that your lordship will claim will get this from page 32 lordship,
Page 30.
32.
Show us another voters list of that Korsakati village.
Malak, that is
Whether it contains check or box, let us see.
Malak, containing box that is page 32.
32.
Malak, this is the land documents
No, land is different.
and voter list, another voter list.
No, no,
lordship.
show us the same voters list.
Malak, page 20, 21 lordship.
Page 21.
Karim Sheikh.
Is also Sheikh.
My lord. Here
Something with
lordship,
box.
my lord, here, my two grandmother name is reflected, Bosirun Bewa and Koripul Bewa,
Sorry,
page 21.
21. Grandfather is Moin Sheikh, Moinuddin.
And grandmother's name, two grandmother's name, Bosirun Bewa and Koripul Bewa.
Where are you getting the demands?
Yes,
Acha, they are the
grandmother of the
grand,
petitioner, grandmother of the petitioner. Mother of Karim Abdul Karim Sheikh Lordship.
not the grandfather. The grandmother,
My lord,
they are the wives of Moinuddin.
Moinuddin.
And Abdul Karim Sheikh is the son of Moinuddin.
My lord.
Okay.
Now, if your lordship kindly come to page 32, three names you will find, your lordship will find. This is the land document of 1960.
No, we are difficulty Sheikh and box. What
Yes, that-
material we have?
That's why lordship,
Page number
page 32 lordship, 32.
32 we have read it.
My lord, Bosirun Bewa, Porimun Bewa, wife of Mondi Sheikh, Porim Box Sheikh, with the Mondi Sheikh.
You are Abdul Karim Sheikh, you are Abdul Karim box, you are Karim Sheikh
Yes.
box.
That is the,
Who will verify all this?
that's why lordship, this.
No, who is going to verify now? Somebody has to give evidence that they are the same person.
No, they are the same person, that's why lordship, these two
Other than
documents.
your statement, how do you verify all this?
All these two documents, lordship, voter list as well.
We have
as-
read the documents. After reading the documents, we are asking you.
Same.
And that
because-
is the reason why the tribunal rejected.
No, tribunal is found that there is a relation.
No, one of the reason for rejecting that Sheikh box Abdul and Karim without Abdul. So now to arrive at a conclusion that the tribunal is wrong, what further material you have to say, to show that these are the same person?
My humble submission, lordship,
Mr.
Relying-
Khan, your submissions are your own statement, your own view.
lordship, by relying the page number 19 and 21. Here, lordship, Abdul Karim Sheikh is given. Father's name is given Moinuddin. Along with the mother's.
No, you see, you have established that you are the daughter of Abdul Karim box of Kurshati village. Now, how will we conclude that Abdul Karim box of Kurshati is a citizen? For that purpose, you refer to the 66 voters list
Madam,
of Kurshati. But that is Abdul Karim Sheikh
madam,
and not box.
box.
And tribunal rejected your claim, saying that you could not produce any material to show that box and Sheikh, they are one and the same person. Here also, you are only making your submissions and statements. Show some material. How can we otherwise overturn the view taken by the tribunal? They are not wrong.
In the written statement, we have,
Written statement is your own statement.
my lord. There is,
Something to show that these two persons, Box and Sheikh, they are the same person. Or that the name Box and name Sheikh are interchangeably used in respect of the same person.
that only lordship, the page 30.
Now, you are leading us to a situation where the tribunal took a contrary view, saying that you could not produce any material to show that Sheikh and Box are of the same person.
Madam.
Same argument you are raising before us, asking us to take the other view. How can we do that?
So far, documents is concerned, indicating that. Sheikh and
Petitioner
Box-
may produce any document to show that Abdul Karim Sheikh, whose name appears in the voters list of 1966 of village Kurshati, and that of Abdul Karim Box, whose name appears in the school certificate at page annex of 15, page 44 to the writ petition, are one and the same person. List after 2 weeks.
Time being 43.
With Abdul Karim Box, you can, you could establish your link,
Page
but whether Box is a citizen,
Well, at page 30, there is a GP certificate. Lordship.
We have read it.
That was GP certificate, that was proof. That is pouring box is there. Obviously.
How can the Gaon Panchayat be custodian of all the information in this world? And whatever information you want, we'll certify.
And as per his evidence, Lordship, he has collected from president and GP members. Lordship.
Very good. In some matters, we have gone a little deeper and we could notice in what manner these certificates are issued.
Let me start.
So the credibility is going down. One Gambura today, we accepted it because he was an 81-year-old man who says that these people are my neighbor, I know everything. We accepted it. But if out of the blue, these Gamburas and secretaries, they give one certificate, that will not mean that a fact is existing.
So,
What further material you can have? You just show that Sheikh and Box are the same person. Yes, Mr. Mojumdar.
Lordship, page 30.
Page 30. Yes.
Lordship, Rahmat Ali is his father, against whom no notice was issued by the state lordship. And his.
Adjourn on the
citizenship
prayer
also
of
has
Mr.
been
L.R.
down.
Mojumdar to examine the materials available on record. You still have not noticed. We have noticed something in your favor.
All right.
Item one for orders.
Is there any application for condonation of delay? Delay had been condoned. Delay condoned हुआ नहीं this one. Resulting in the endorsement of objection is an application was filed and that will be for condoning the delay. It will be delay, hence land council is for 2 weeks time, but liberty to file application for condonation. Now this application for condonation is here. Condon for delay of how much it is, Mr. Sigda? Delay of how much it is? No, you must. No.
Speaker.
Microphone.
Mr.
About 2 months.
Shekhar, this is condoning the delay in filing the review petition.
My lord.
How much delay is there in the review petition?
About, will be about 2 months, my lord.
4 months,
2 months. My lord.
2 months.
Yes.
Yes, Mr. Pine, do you object to the delay being condoned? Okay,
My lord, we condone the delay, my lord.
no, don't go on merit. Do you object to the delay of 2 months being condoned?
My lord, I have objection.
Sorry.
No objection.
Heard Mr. E.S. Shigdar, learned counsel for the applicant, also heard Mr. Sorin Ambujidiwa, huh? This interlocutory application is instituted for condoning a delay of, where have you stated the number of?
My lord, in para two, my lord, I have stated about the date of judgment and date of filing.
Delay in filing the accompanying review petition. In para 2 of the interlocutory application, it is stated that the review petition was filed on 24/1/2020 against an order dated 19/9/2019. It is also stated that under Article 124 of the Limitation Act 1963, a review petition is required to be filed within a period of 30 days from the date of decree or the order. Consequently, it is stated that there is a delay of approximately 2 months in filing the petition. We are satisfied with the reasons stated in the interlocutory application for the delay indicated above. Mr. J. Paying, Land Counsel for the Home Department of the Government of Assam, also do not object to the delay being condoned. Accordingly, the delay in filing the accompanying review petition number 81/2020 is condoned.
Right.
Review petition be listed for its consideration on its merit.
Deep love lesson.
Item four,
आगे तो लोगों ने लगे आगे तो लोगों ने लगे I was listed I give me nobody movie. Fine. Can you hear the review petition on its merit today? Or we have to list it on some other day?
Want to list in some other day because
Some other
I'm
day.
sorry, my lord. I will have to take a copy of from my friend. I don't.
Yes, Mr. Majumdar.
Like-
Yes, Mr. Majumdar.
My lord,
Review on what ground?
lordship, review of order passed by this honorable court lordship, that is at page 52. Page 52, it started from page 52 lordship, and finding of the honorable court at page 53.
The review petition filed on 20. Mr. Majumdar,
My
Lordship is pointing out that this petition was filed on 5/10/2020, whereas it is against an order of 26/8/2019.
lordship, actually, we have preferred a SLP before the honorable Supreme
No,
Court.
but still you have to file a condonation petition. The fact of you filing an SLP may be a good reason to
Lordship,
condone the delay,
lordship, that
but
is actually.
as the procedure has already been set, that in the event of delay, it has to be accompanied by a interlocutory application for condoning the delay. We maintain the same procedure.
Lordship, actually, the right is granted by the honorable.
Mr. Majumdar, Mr. Shigdar will have some feeling
Lordship,
that in my case, I am required to file condoning petition. For Mr. Majumdar case, it is not required. So let us maintain
Lordship,
parity.
Lordship, with some
Mr. L. R. Majumdar, Land Council petitioner, seeks for an adjournment to file an application for condoning the delay, if any, in the company, the delay in filing the review petition.
obliged.
item four,
May I please your lordship? Lordship, my senior, Mr. N. Hassan is out of station for medical purpose. Later may kindly pass out for.
Your
pending
senior
upload,
and
please.
son is out on medical purpose. So what is your name?
A. Ali.
Mr. A. Ali, Land Council appearing for the review petitioner seeks for an adjournment to file application for condoning the delay in filing the review petition, if any.
God bless.
List accordingly.
Item 5,
May I please your lordships?
Is there any delay?
Delays there, but since there is a writ petition lordships. writ
No,
Petitions, they
Mr.
are,
Borgoya,
yes, lordships.
we cannot
Some-
adopt two
judgment
different
of
standards,
our
one from
High
Mr.
Court.
Borgoya and one from Mr. Shikdar.
No, not lordships, yes, yeah, if a lordship
So
already
if
passed
the-
order, I will file an
Uh-huh.
application for contestation.
If the procedure has already
Lordship,
been adopted
says
by
lordship,
another
yes,
court,
lordship.
that in review petition,
Lordship.
condonation petition is also required. Maintain the parity,
Lordships, I will file it,
same order.
lordships.
Because Mr. Barbuya, let me tell you, there's a division bench judgment which says of our court, which says that it is required.
Yes.
So better do it as lordship is.
Earlier judgment, lordship, I gone through it to 1997 to Libyan not required, that's why.
Mr.
I am
Borgoya,
lordship, I
if
am not
we,
disputing now.
if we intend to
not disputing.
contest this issue, whether delay
Lordship.
condonation is required or
Yes.
not, and if there are two contrary division bench judgments,
Lordships.
make an application, we'll refer it to the full bench
Lordship,
to
I will
take a
file.
call whether it
I
is
am
required
not-
or not.
Now I am not disputing,
But-
lordship, because.
But once a procedure is in place
Lordships,
where parties are filing condonation petition,
I am,
a situation cannot be accepted that for some petition will
Lordship,
insist and for some others will
I
not.
agree, lordships.
You have to maintain
I'll-
parity.
I- Lordship, I am,
Okay.
I'll file.
Fine, fine.
Oblige, lordship.
item 6,
What is the I for? madam?
IMA is infructuous. Already he is being released from the detention camp. So and there is delay, lordship.
MSD Ghosh, Land Counsel for the applicant states that in view of the changed circumstance that the petitioner detainee had been released from detention in the meantime, no order is required in the interlocutory application. Interlocutory application stands closed.
Yes,
On the
lordship.
main petition.
Main petition, there is delay, lordship. Yes, lordship, I'll file.
MSD Ghosh, Land Counsel petitioner seeks for adjournment to file an application for condoning the delay, if any, in the review petition.
item 7,
K. Colita. Sorry. Hmm. Hmm. I would say K. Colita. I don't think the police.
Restoration.
I thought, I thought. It's not serious. It is noticed that when the matter was listed on 33/2022, none appeared for the applicant. When it was again listed on 11/8/2022, none appeared. And there was an observation that if on the next date, the applicant remains unrepresented, the court would pass consequential order. Today again, when the matter is called, none appears, dismissed for non-prosecution. For restoring.
This is for restoration petition. Yes.
We have taken note that the IA was for restoring the dismissal of non-prosecution of the accompanying review petition.
Concerned of the other side, I like to mention item 6, your lordship.
Item 6.
Lordship, your senior counsel out of station, your lordship.
Item number 6.
Yes, your lordship.
Your name?
PK Bora, your lordship.
Adjourn on the PK Bora, Land Council appearing for the petitioner.
Much obliged.
item 1 and 2 for motion.
ultimately, what to do with these matters?
May I please, your
See,
lordship?
we have heard this matter for about almost 10 days.
Yes, my lordship.
Now, the brief is taken away from the learned council. That's
Your-
what was stated by, I think, Mr. Das on the last day.
Your Honor, on the last day, that is second of March 2023, the petitioner was personally served a notice for his personal appearance in this, before this court, Your Honor. And accordingly, the petitioner is present, Your Honor.
He is present.
Yes, Your
Please ask him to come. Where is he? Where is the petitioner? Why doesn't he come forward? You are Subrajyoti Bhorali?
Yes, sir.
Please come forward. Earlier, you engaged Mr. Das, again, Mr. Das senior advocates and a set of counsel.
Yeah.
On the last date, they said that the brief had been taken away from them. And this is a matter we have heard for almost 10 days. So what do you intend to do? Because after wasting judicial time for 10 days, we can't now allow you to withdraw your counsel.
So factually, the factual thing is this, I have not withdrawn my brief from him. This is, and he had sent me a mail at 8:25 PM.
So
Right.
now, do you intend to engage some other counsel or you want to argue on your own?
I think he permitted, I'll plead myself, sir.
You want to argue matter on your own?
Yeah.
Please start.
Hello. We have some today reservation. Mr. RKD Chaudhary is appearing in this matter. He is in court number 1
Okay.
on legs.
Fine.
And department has asked him to appear in this matter. So my lord, and he was not sure whether today the matter will be taken up. And we would also like to, my lord, file an additional affidavit. My lord has on the last, I will just,
No, we continue from the hearing what had transpired on the earlier days.
my lord.
We are not starting it afresh just because the petitioner now comes in person.
My lord,
We'll continue from the last date.
16 to 22, 23, my lord, that order, my lord. So on this order, my lord.
Let's see for adjournment, why the provision of section 8 of the prevention order had been invoked in cases where no property or any recorder is involved.
My lord.
So you intend to file an affidavit?
We need to file an, because these were not the part of the, my lord, the pleading in the
Okay.
writ petition. The writ petition was in a very different ground. So now, since this has come, we have to rebut to this. So that's why we'll have to
No,
file.
we are
it.
not following. How many writ petitions are there?
My lord, there are 2 writ petitions, my lord. The first,
What is WPC 6693? It is for what purpose?
my lord, they have come challenging section 8. And my lord,
Section 8 of the act is under challenge.
No, my lord, can I explain? So far, the writ petition 6693 is concerned. It is basically, we have challenged the show cause notice. Show cause notice in the sense,
Show cause notice
show
under
cause
what
notice that
provision?
being served by the executing
Under
authority.
which provision of law?
It's a section on 17(4).
17(4). show cause. Action song. PML. Have you read our earlier orders and are you aware of what
Yeah, I heard the facts.
Mr. Petitioner, please don't be so excited. Come down. Be more relaxed, give the answer properly. Are you aware what took place in the proceedings on the earlier dates?
Uh,
If you are not aware, somebody has to make you aware. Because we are continuing the proceeding where it was left in the earlier hearing. We are not starting a hearing afresh just because you are in person. So are you aware what had transpired on the earlier dates? Either yes or no.
I have gone through all the orders and from that whatever knowledge I have acquired from that only I could.
And you are not aware what happened. You ask your earlier counsel what had happened. Only then you can continue with the proceeding. Now you have picked up this proceeding from a particular stage where a substantial proceeding had already taken place. So you should be aware what had taken place on the earlier dates. Only then you can continue.
Then I have to take some brief.
I
from
think
the-
something has to be taken. Otherwise, how will we aware what had taken place in the court? And this is not just 1 or 2 dates, almost
Yeah.
about 8 or 10 dates the hearing took place. What happened with your earlier counsel? They had gone away. They are not appearing anymore
I have.
because they were arguing the matter in a particular direction.
Yeah.
So we don't know what you are going to argue now, whether you're going to continue with the same direction or you're going to take some other ground or do some. So have you understood the difficulty of the court? After wasting judicial time for almost 10 days, and these were quite long hearings, I remember. We can't allow that judicial time to be wasted for nothing. So either we continue with the hearing from where it started, where it ended on the earlier dates, we can allow you to continue. Or the other option is we'll simply issue notice, list it after 2 months without anything. Then we'll hear you afresh. It will be put in a regular hearing course, we'll hear you. This was given an expedited hearing on the request of your counsel. And mind you, the matter is still in motion, that's why. Whole purpose was that some legal issues are raised, we'll decide the issue and pass a final order. You take your call.
I think I'll engage a new.
And the
counsel.
new council will also start from the
No, sir, from where it's being.
where it left
yeah,
earlier.
yeah, it will
So
be
then you
continued.
be aware what was argued by your earlier council.
Yeah.
Take the briefing from them. And if you want that the last 10 days judicial time should go waste, then we are issuing notice. We'll issue notice, we'll hear them, they'll give reply, we'll see what is to be done.
No, my lord, I think my basic intention is whatever we had, I think the 10 days has been spent, so it should go waste. So we'll start from that
So
point.
you're-
itself.
Yeah, you're welcome to continue from where your earlier council had.
Yeah, I'll
In the same thing. So you find your.
We'll file the affidavit.
Anyway, the first petition is challenging a notice under section 17. What is section 17? What is section 17?
Section 17 is basically the whole procedure of search and seizure.
So you are challenging the search and seizure that had
Search
taken.
and seizure, and then the next proceeds. Because
No, make your mind, make up your mind. You are challenging the search and seizure or you are challenging the procedure adopted in the search and seizure?
procedure adopted in such.
Procedure.
because-
So you are, Mr. Your name, Bharali, Mr. Bharali. Either you challenge the show cause notice itself that it is not maintainable in law. Okay, that notice under section 17 we mean. Or you can challenge that the proceeding under section 17 is maintainable, but while going ahead, whatever procedure of law is required to be followed, that had not been followed. Which is your case?
The whole process of search and seizure is being challenged in writ petition, criminal writ petition 22, which has been disposed of.
Disposed of, my lord.
And second
Minor
was,
disposed.
yeah, then after that, once that's been disposed of, because it is parallelly, it has gone. Because the whole process has started parallelly. And then we had challenged this
original application, which was supposed to be sent by the higher authority. But I think the enforcement director, they had submitted these applications by.
Earlier, your, if I remember, your council was taking different grounds that one deputy director could not
Yes.
have sent, some
Yes.
assistant director ought to
Yeah.
have sent.
Yeah.
Then again, another communication, the deputy director ought to have sent, but it was done by the assistant director, just vice versa. I think this was
This is the.
your submissions were of that nature.
Yeah, this was what WPCC
Now-
said. That is what we have. submitted.
Now, these proceedings are related to, I think, section 8, I suppose. Adjudication,
Adjudication, my lord.
adjudication.
Section 8,
Huh.
page 17, my lord.
Is there any adjudication proceeding necessary when there is no seizure of any property?
My lord, that is what we want to bring on record, so an affidavit, we'll reply, my lord.
Because this entire adjudication proceeding is that what will you do with the seized property? Because the process is still in investigation,
My lord,
it is yet to go to the court.
my lord,
So under the Mr. Dhar,
my lord, my lord.
just wait. Under the PML Act, properties are seized and taken over by the state. So the question arises, what will happen with those property? To answer that question, what will happen to the property? The law also provides that there will be a process of adjudication.
Yes, ma'am.
But we are putting with a question that if there is no seizure of any property, only records, etc., is there any necessity of an adjudication? Because these will be like seizing any other documents, etc., like any other proceeding. You seize it, you keep it with you, and you utilize these documents, etc., for your charge sheet, etc., and it will go to the trial after that.
That is a, my lord. will
So why
grant-
do you go for adjudication?
My lord will grant us 2 weeks' time. In the meantime, we'll bring everything on record, my lord, for an affidavit. In the meantime, let him also get the briefing.
Suppose Mr. Bharali's house would have been seized.
My lord.
Then the question would have come for adjudication. What will you do with the house in the meantime? But what you have seized is, what I believe, some photocopies of some documents here and there.
My lord.
Where is the requirement under the law to send these documents for an adjudication under section 8?
My lord, will reply, my lord. Grant us time.
I think the last hearing was at that stage.
Exactly, ma'am, exactly. Ma'am. That is what my lord's order reflects. The second last order, my lord.
Mr. R. Dhol and counsel for the respondents in the ED
My lord.
raised for an adjournment of 2 weeks to file an affidavit in response of the query raised in the order dated 16/2/2022, list after 2 weeks. Mr. Survojyoti Bharali, petitioner in person, is present. And in the meantime, if you want to engage a lawyer, you can do so. It's up to you. It's your current view.
30th March. Item 3 for admission.
In item 3, Lordship, we are praying for a certain accommodation, Lordship, as because Lordship, we have been directed to bring on record the report pursuant to the direction of this honorable court. And we have prepared the affidavit, Lordship,
What kind of report, Mr. Sharma?
Regarding Lordship, our given
Report that may be prepared by
What
the
has been
committee or
committed,
by the
Lordship, in-
court.
the answer script of the petitioner, Lordship.
The double tick mark. that
Double
one.
ticking.
so that report, Lordship, we have to bring on record, Lordship, so some time, Lordship. 2-3 days, Lordship. And
I think in the answers script of this petitioner, certain questions were double ticked.
Lordship.
He takes a stand that I did not do the double ticking. Whether he had given the right answer or wrong answer, he had given only one single tick. So now the question arises, who had given the second
Yes.
tick in the answers? So you tell us.
Lordship, that is the report we have been directed to produce by way of an affidavit. Lordship, we will produce it during 2-3 days. It is already prepared. But the person concerned is going to put the signature for some this budget session, Lordship, some. That is the only 2-3
Mr.
days.
Sharma, that is unacceptable. If everything is prepared to put the signature, you
Lordship,
need
Mr.
another
Abdullah,
few weeks.
Actually, Lordship.
How can that be accepted?
Lordship, in this case, the additional as Mr. D. Mozumdar is appearing. I have been make a prayer for
No,
only
let
2-3
Mr.
days
Mozumdar, no,
accommodation.
no. Let Mr. Mozumdar appear. He will not appear. If you need time to prepare the report, we have to do lot many study, lot many
Lordship.
inquiries, etc. We understand you need more time. But if the report is ready and you want to put only the signature,
No, Lordship, they.
why do you need several weeks to put a signature?
No, Lordship, in the, I am not talking about the report, Lordship, in the affidavit, Lordship, it is to be shown. And.
So that your man does not have time to come to the
No,
report.
Lordship, that is also not,
Ask him to remain personally present.
no, Lordship, that.
We'll
Only
inquire
1 or
from
2 days,
him.
I think it is sent that.
Will inquire from the person why a responsible officer does not have time to come and swear an affidavit which is
May-
required in a court. proceeding.
May I get the proper instruction after some time, Lordship, after some, time. Only 5 minutes, Lordship, let me get the instruction,
Get it?
Lordship, I am coming.
Or else the view of this officer is the requirements of the court proceedings. Keep it
No,
aside.
Lordship, it is
Later on,
already, I have been told.
all other duties are more important for me. Please don't disturb me with this, all these affidavits and all.
That
Is
not
this the attitude of this officer?
I don't think so, Lordship, let me get the
Please
instruction.
give the proper answer.
Lordship.
Item 4,
Yes, item 4.
this matter was heard by
That
your lordship.
force matter.
May I suggest one thing, madam? Considering the prayer they had made to incorporate their name in the village register, madam, forest village register, let that part be decided by the DFO, madam, depending upon their documents and claims, madam.
Why should it be allowed if it is,
Yes.
if it would not be permissible in law?
Otherwise, my argument is not permissible. It is not permissible for Delhi.
And what is a forest village?
Forest village, my lord, as defined under the forest regulations, my lord. But there is a case, my lord, their name was supposed to be inserted in a forest village. It was never done.
No, no, what is a forest village?
Assam forest regulation, my lord.
Assam forest regulation.
Yes, my lord. Regulation section 29, my lord. The state government may by notification in the official gazette constitute
Mhm.
any land at the disposal of the government if not
Sorry.
for the benefit of the any village community or group of village communities and may in like manner vary or cancel such knowledge. In respect of the petitioners, my lord, this
You are reading 29.
29, my lord, forest regulation.
It's not a forest village, it's village
It's
forest.
village forest. my lord.
And Mr. Goswami,
I understand, my lord.
there is a big distinction between a village forest and a
Forest. village.
forest village.
True.
Village forest is, it is otherwise a village in a, it's a otherwise a revenue village. But in the revenue village, certain forest exists. Government by notification constitute any land at the disposal of government, a village forest for the benefit of any village community.
Right.
So therefore, whatever forest exists in otherwise a revenue village, that is notified under section 29,
My lord.
so that the village community can have the benefits of that forest. And when you talk about a forest village, this is located inside the reserve forests.
Exactly, my lord.
And here is a case, it is inside the reserve forest.
Inside the reserve.
So how section 29 is applicable? If section 29 is not applicable, show us the source of law where inside the reserve forest, you can have a forest village.
No, there is no none, my lord. In fact, my lord, that
So
rule-
these petitioners are seeking a direction that they being given some allotted some land inside the reserve forest by one conservator of forest. Now their name should be
Entered in the.
entered in the Jamabandi. Jamabandi is a concept under the land revenue
Right.
regulation which relates to.
Revenue land.
So it's a inconsistent situation.
Inconsistent. And moreover, my lord, the rules that my lord has already seen was not framed under these two sections. It was framed under 72E 74, which is no way connected.
Of the Indian Forest Act. Indian Forest Act is firstly you said not applicable.
No, I'm not saying even this. There's a rule for forest village, constitution of forest village. That rule, my lord, is framed in exercise of powers conferred under section 72 and 74 of the forest regulations,
Does it,
not
does
under
it,
29.
does it empower you to create forest village?
Yes.
Yes.
It says, my lord, forest village may be established within the limits of any reserve forest on sites.
Who says? The rule
Rule
says.
says, madam.
And to frame that rule, you exercise powers under section 72,
72, madam, not under 29,
72.
which is a very general power.
So does the section 72 empower the government, Assam government to constitute any forest village?
No, madam. Does not. And moreover, my lord, under the Forest Conservation Act, presently it is absolutely impermissible, madam, to use forest land for non-forest purpose.
My the page 109 of the rules, my 109.
109.
Yes, ma'am.
What is there in 109?
Yes, these are the rules framed under 72. my-
This is what we are asking.
Yes,
Yes, but this is in our affidavit, madam.
yes, yes. Now, the forest village. may be-
Mr. Chaudhary, what the question we are raising is, these rules are admittedly framed under section 72E of the Indian Forest Act.
1891.
No,
Indian Forest Act or Assam Forest Regulation?
Regular.
Of the Assam Forest Regulation. Does section 72 empower the government to frame rules and create forest village, village forest? Not village forest, sorry, this thing, forest
Forest
village. It does not empower.
Yes, madam, it is there, madam. Next year, kind of thing.
Mr. Chaudhary, does
Power is
the,
given to DFO and Conservative Forest. madam.
Mr. Chaudhary, how many times you should repeat the question to you? Rules are providing, no doubt. But the rule is framed under section 72E. Does section 72E empower the government to make rules and create forest village? If it does not, this rule is in conflict with the main statute.
That is
So
not
how
under-
can it be given effect?
That is not under challenge, so madam, nobody.
May not be,
That rules.
but as you are seeking a direction,
But we have,
by relying on this rule, we are also required to examine whether these rules are constitutionally valid or not. Otherwise, you are seeking a direction from the court that invoke these rules and pass an order.
no, we have been, madam, subject to what your lordship say, madam, page 45, we have been given specifically, madam, with regard to this villages, madam. Page
I
45,
understand.
our initial allotment given by the
Understand?
Conservative.
So these are in conflict with almost all statutory provisions.
That might.
There cannot exist any village inside the forests, otherwise it is not a forest.
But this was made in 1930, madam, this rules, it's been
Maybe,
since 1930.
maybe. Even if it is existence in for a long time, but if it is without any
That-
authority of
that
law,
Of course, law, if it is,
whenever the matter comes before the court is bound to go into that question.
but we have been, madam, actually, in terms of the order, so long it is valid, madam. We have been allotted. in terms of
Mr.
this-
Chaudhary, if you are interested in having land, make an application under the land policy. Get wherever land is available. But how can you insist on that just because some conservator of forest in 1970 allowed us to get into it, which again is an atrocious order, if you read the language of that order. And what power he invokes this rule 2 of this chapter 7,
72 E.
And
or rule
these
two.
rules are framed under 72E.
Yeah.
72E does not empower the authorities to create any forest village.
72.
How can all these things be regularized? The only right of the petitioners we recognize is that they may have an entitlement to get some land under the government of Assam. And that entitlement is under the land policy. Make an application. We'll
There is
allow-
another aspect, madam, it is because landless people are there. That is, here we have offered our service to the forest village, madam. We have been so till today, madam. We are giving our service.
So that means
But
the,
for that only they have made up this rules, I think, for that
For-
only.
are we to understand that as because the petitioners have given some service to the forest, so they are entitled to land inside the forest?
Not, madam, in
Under
that way,
which
not
rule?
heritable in that sense, but this rule itself says, madam. So if your lordship says rule
And
is,
this rule is also against you. It clearly says that it is not heritable.
no, yes, but yes,
Please come to page 100.
yes, page 6, madam.
But nothing in this rule shall be held to recognize any
Yeah.
heritable right in land allotted to a forest village.
But it says name of his male heir will be registered as a forest villager if he is considered by the DFO to be
But
suitable.
understand, but the later part, nothing in this rule. So that means it is a non-obstant clause. Whatever is provided is nullified.
But nothing in this rule shall be held to
Mhm.
recognize any heritable right in land allotted to a forest. villager.
And these people,
I am not asking for heritable also, madam.
then what you are asking?
I am not simply saying, madam, your lordship kindly see, on the deceased of a householder, the name of his male heir will be registered as a forest villager if it's considered by the DFO suitable. So condition is there, madam.
Yes,
If they
nothing wrong.
find that my service is required or for the
There is-
interaction of the
there is-
forest village, I'm,
There is nothing called forest village. Forest village may be established within the limits of any reserve forest. On sites, the location of which shall be approved by the conservator of forest.
Well, it was up to 1930. Perhaps at that point of time, it may be a good law, but today's context, it cannot survive, my lord.
so
Because,
somebody
my
must
lord,
say,
my
my
lord,
lord.
appreciate one thing, my lord.
In
19
today's context, Mr. Chaudhary, what we are aware is hundreds of people are occupying the forest land, forests are being denuded,
Nobody is approving. that.
environmental problem is being already in existence.
my lord, may I submit one thing, my lord?
How can
But that
we
will also do not
give a
approve, madam.
judicial approval to all these happenings?
But here is a case, madam, since 78, this we will have done in terms of the rules. So long, this till today, this rule is valid, madam, until unless your
What do you
lordship
do?
interferes. madam.
You withdraw the rules.
This rule has to go, my lord. We will not apply this rule because, my lord, in the meantime, in 1976, constitution was amended. Earlier, it was in the state list, forest. Now it has been incorporated in concurrent list. So any law that is existence in Assam, my lord, in contradiction to the central law, cannot survive, my lord.
And now the Forest Conservation Act has come in.
Exactly. No, it starts with the word notwithstanding anything contained, madam.
But there is subsequently it came, man, 80,
80,
madam.
and if
We
we,
are first 76.
So after the 80 Act, Central Act, notwithstanding anything contained in any provision,
exactly,
this includes the rule at 109.
exactly.
So this rule has become redundant. So now no right can be claimed under these rules.
If there is a conflict with that, my lord, then in that case, of course, my lord, your lordship.
No, Mr. Chaudhary, it's not a case of conflict. We will follow the statutory provision that is in force at present. That is the Forest Conservation Act.
In that case, your lordship, please.
Then I think we-
Sometime I'll let me explore to, madam, because actually, madam, it is a very question, madam.
But
relevant
Mr.
question.
Chaudhary, at the same time, if your only consideration is that land is required, we'll allow you to apply under the land policy. Do that. We don't want to deprive any citizen
That's true,
of
madam. I
any
appreciate your
entitlement
lordship.
of any land.
I appreciate your lordship.
But what we are more concerned is
About forest preservation.
about the condition of the forest and how can we give judicial approval to these acts? Whatsoever may have happened in the earlier years.
Well, 2-3 days time, just let me see. Let me have some instruction also, my lord. Whether there's- Next Monday or any other day, my lord.
Mr.
Subject
H.R.A.
to your
Chaudhary,
worship.
Learned Senior Counsel for the petitioner seeks for an adjournment to examine the aspect
Yes.
as to which law would prevail, that is the provisions of the the
Rules
conservation-
framed under
No, Conservation Act. Forest Conservation Act 1880 the 1980,
1980.
or the rules framed by the government of Assam under section 72E, 74 and 75 of the Assam Forest Regulation, which is stated to have been established sometime in the year 1930. The issue assumes its importance in as much as the provisions of the Forest Conservation Act begins with a non-obstant clause that is notwithstanding the provisions of any other law that may be in force. Adjourn on the prayer of Mr. Chaudhary to be listed on Swenson.
Anytime next week, my lord, let me have some.
Even under the Forest Rights Act also, my lord.
Be fair to the environment. You take your exercise your right for any other land, wherever you are entitled.
Next Tuesday, my lord.
Next Tuesday.
But leave the forest as they are. Anyway,
Your lordship anxiety, we are similar. I have also
Anyway,
same of anxiety.
if you go by the satellite mappings, a big percentage of forest is already gone. If you can conserve or preserve whatever is left, it is good for everyone, not just for.
But
the-
actually, madam, so in order to preserve forest, people's service also required, my lord. In
For
order to
that,
preserve forest.
nowadays forest personnel are there, my lord.
And this is that.
Very- very-
Yes, only madam, in time is there, madam.
Interim, my lord,
Status quo.
that,
I given
this
undertaking.
so and so, it came to till the
Status quo,
next
one
day.
will be done. Oh, so, how to make those-
Please, sorry,
20,
30,
23.
30 March.
30.
30.
Public.
Unless status quo, my lord.
Interim earlier to continue till.
Obliged to, obliged.
Item 5 for orders.
Made previous lawsuit.
Lordship, the records were required to be produced. We have received it, Lordship, but Lordship, sometime is required to correlate this.
Mr. Sharma, a little louder.
We have received the records, Lordship, that was called for, Lordship, in.
You have to examine the records.
We need to examine it, Lordship, and sometime is required. for-
Mr. MP Sharma, Land Counsel for the respondent Guwahati High Court states that the records as required by the earlier orders have been received, but some time is required to examine the same. Pray aloud, list on 30.
Obliged, Lordship.
Item 7.
What's up?
Review petition. Yes, Mr. Bosco, what is the review?
My lord, the direct secretary to the elementary education, instead of it was mentioned as secretary to the secondary education, my lord. Similar matter, lordship, against the same judgment, my lord, I filed another on last second.
Why are you filing a review? Why don't you file an IA for correction?
Sorry,
Anyway, this is not a matter of review.
on last second.
Can you pass the same order?
Same.
Mr. Bora? Pass the
So
same.
lordship, already there is a page number 85, lordship already there, 15.
Page number.
85.
On
That is,
last second.
He wants a similar order.
Only read petition number will be different.
In petition number kita change kori dibo.
my-
In this copy, you please mark the changes. of
Lordship.
the case number. Pass the same order.
Obliged.
I appear for respondent 3.
I'm appearing for 1 and 2.
Item 8 for hearing.
Respondent kira lolo.
This matter, my senior was required to produce a judgment with regard to that.
Your senior was present sometime back.
Yes, Lordship, that judgment, he, on that point itself was not this.
No judgment is available.
But sometime he has asked for some time, Lordship, so.
You provide that if an interference is made on an inquiry report on any technical ground, the interference can also be fragmented in respect of a particular charge and not the complete.
According to him, Lordship, there were some judgments, Lordship, but he could not trace it out. Sometime, Lordship.
Mr. MP Sharma appearing for the petitioner states that the judgment to be produced as required by the order dated 2/3/2023 would require some further time for its examination. Pray aloud, list on 30.
Obliged, Lordship.
Item 9.
Fine. What is item 9?
Make legal lordship.
on the prayer of Mr. R. Dhor, then list again for further hearing. What is this, Mr. Dhor?
Also, the petitioner service is
You appearing, Mr. Kaur?
I am appearing for the PNRD also.
Mr. Dhor, for who did he appear?
Okay.
That's the last order.
Please take.
Where is the original order of appointment? As LDA in Deputy Commissioner?
original appointment is annexure. In annexure, page number 17, annexure 1 is in our petition is available.
Sorry, page number 17.
17. Yes, for.
No, we are asking you the original appointment order as LDA in the DC office.
Original appointment order is not available. Ma'am. That's why I asked them to produce the record, my lord.
When was the petitioner initially appointed?
Initially.
In which year?
Initially appointed in 10/10/1960.
10/10/1965.
65.
He was appointed
Joined government service as LDA in Dibrugarh 10/10/1965.
in the office of the Deputy Commissioner.
Yes, then he transferred to
Then
Dibrugarh.
he was placed in before in the DRDA
Then
in 1982,
he
and he retired from service on
retired on service on 2016, 2006, 10/5.
2006. For how many years the person worked? 50 years.
Yes.
So if he worked for 50 years, he must have been appointed when he was 10-year-old. I think something wrong somewhere. Check up the information.
As per advertisement, annexure to page number 18, he was temporary.
Ah. These are applicable on these. So did you apply pursuant to page 18?
Page 18 is the advertisement, it was issued by the Director of Rural Development.
When we understand it's an advertisement.
Or is it
Did you were you appointed pursuant to this advertisement?
Yes.
Yes,
Yes,
but this advertisement is for post of
DRD.
in the DRDA.
Yes.
So you are directly recruited in the DRDA.
Yes, for this advertisement, I was appointed on 1/9/83.
Yes, Mr. Kaur, Mr. Sharma, Mr. Dhor.
Your lordship,
Please
the,
help us with the facts first.
yes. Your lordship, the.
No, just a minute. If the petitioner was appointed pursuant to the advertisement at page 18, that is 2/4/1983, then why did the Deputy Commissioner pass the order at page 17?
Your lordship
in
is
82, that is 1 year before,
1 year before you said.
and placing his service in the DRDA. Why it happened?
Your lordship, being the chairman, deputy commissioner is the chairman of the governing body of the district rural development.
No, let him
agency,
become the
lordship.
chairman.
Yes, your lordship.
If the statement of Madam Begum is right, that there is an advertisement in April 1983 for 134 posts of
Yes.
UDA
Yes,
in the DRDA, and the petitioner applied pursuant to that advertisement and got appointed, then why was the order of 26 May 82 was passed? That is 1 year before.
is it 82? He was appointed by the district rural development agency as a LDA, your lordship,
Where?
in Dibrugarh.
In which office?
In the district rural development agency.
Where is that
office.
order? Let us see.
From the pleadings, your
So
lordship.
forget the pleading. You give a record.
But yes. That record, so far as his appointment in the district establishment and subsequent to his posting,
Mr. Kaur, look at page 17.
yes,
Please read it.
in the interest of the public service, the service of Sri Thanasabara LD of this is amalgamated establishment.
First two line means
Yeah.
that this person, Thaneswar Bora, was a LDA in the DC office.
Yes, yes,
And this order had placed his service in the DRDA.
DRDA as LDA.
That means originally he's an employee of the DC office.
Yes, it appears so. Your lordship.
So this is what we are trying to ask you for some time.
Your lordship, that answer is not with me, but from the records, it is found that.
Then we will have that answer. Let the Deputy Commissioner Dibrugarh remain present in the court to explain. Let him give the answer.
Your lordship, my learned friend is appearing for the.
You are
deputy
appealing for
commissioner.
Deputy Commissioner. Do you have that answer?
Yes, lordship,
Have you understood the implication of page
lordship,
17?
lordship.
Deputy Commissioner passes an order that this particular person who is an LDA in the DC office, now his service will be placed before the DRDA. That means this man is an employee, originally an employee of DC office.
Lordship. That was the, accordingly, lordship, we have written a letter to them to give us the required records.
To the DC.
Lordship.
What-
And we have received the instructions, though it is it's a old case, lordship, certain documents they could not found, but from the service book, it reflects that the petitioner was never been appointed as a permanent employee. May I read, lordship?
No, we are not on permanent and unpermanent.
Lordship.
That is another aspect. If he is a man of the DC office,
He was, lordship, temporarily engaged.
temporary or permanent, it doesn't matter.
Lordship,
Temporary employees also have their own legal rights.
lordship.
How can the DC place his service in the DRDO? And after serving for the entire career, now take a stand that DRDO is a society, no pension for you. How can you do
But
it?
initially, lordship,
If this man was directly appointed to the DRDA after participant selection, we
Lordship.
understand. Person will be subjected to the whatever provision of law is there.
in the year 1982, I had an order, lordship, this Thaneswar Bora, he was appointed temporarily as LDA under the NREP
No,
work
no,
of the,
where is the order of appointment? Let us see.
that, the lordship, that is also we are facing the same difficulty, lordship. They, only the service book is there,
If the DC,
nothing, no.
where is the service book?
Yes, lordship, this is the service book. Original person, but even then, if your lordship go by the
Doesn't matter.
how the petitioner is engaged, it is written in the front page, lordship. If your lordship go by that,
No, this
Then
is
then we can
the,
find it from the,
this is the comments of the Deputy Commissioner.
no, lordship, how how this petitioner was engaged, Lordship. Those were written.
No, how does the deputy commissioner know? He has to be on the basis of record. We have
Yes,
to see the
Lordship,
record.
that it is written in the service book, Lordship.
Who prepared this service book?
You see this maybe?
Hmm.
The this original, this service book is here also. My learned friend has got that. Well, we have that photocopy only. If your lordship go by this lordship, your lordship can. Last year order the
When was this person born? What is the date of birth of this man?
Date of birth is- date of birth.
Date of birth is 1 October 1947. So 47,
Yes.
53 years. And when did you retire?
Retail to 1/10/2000.
16.
Page
You are-
number 26, my lord. Okay? Page number 26.
No, please say
1/10/2005.
2005 he had retired.
1/10/2005.
Very well, he retired at the age of 60. Hmm. Not 60 also, 58. Huh. He is given a scale pay, he is given increment. He is allowed to cross efficiency bar, everything is there. And he is possibly working in the office of the settlement officer. Although you use the word temporary, there is,
Lordship, he was engaged in different departments for certain period of time. Thereafter, he was released. Again, he was engaged, again released,
then
again engaged.
then what kind of a service is that?
Lordship, that is the, I find it from the service book, it's like that, Lordship.
Granted earned leave also. Everything is there, he's granted earned leave also.
One day here the
Up to 1976,
LD is facing retrenchment from settlement of his
no,
Dibrugarh.
he's opted for revised scale of pay, increment. Haneswar Bora is facing retrenchment,
Yes, Lord.
thereby released from the ASO so and so Dibrugarh order.
Thereafter, he was again joined in Mohkuma Porikhod office in Tinsukia. On 31/5/82, Lordship, this is Dibrugarh's order, so and so Thaneswar LDA is released from the Mohkuma Porikhod office.
What do you intend to do with this man?
Lordship, I am also.
He was just shunted around from this office to this, that office, all around. You can't do it. And now ultimately, finally, he was placed in the DRDA. Today, this man is in settlement office. Tomorrow, he is in Mohkuma. Third day, he is in some another office in between. Yes, so office released. And not only that, you are maintaining a continuous service book.
Yes.
If these are separate appointments, there ought to have been separate service books. You are maintaining one whole service book.
One service.
So before Mohkuma, he again served in the Mohkuma. Appointed temporarily in the office for, he was engaged for some census work.
Yes.
From 1965, he works in the office of the settlement office. In between, he was put into the ASO office, thought that he should be retrenched. And I don't know whether retrenchment is applicable in government service. It's not a labor law. Then he is put in census. Then you put him in Mohkuma Parishad. And ultimately, all of you got together, sent him to the DRDA.
But they was never
Yeah.
been regularly appointed. Lordship, like where
How
was
many-
thrown like anything, Lordship. That is,
So, under which service law you can do this?
Lordship, that is.
Tell us under which service law, applicable service law, the relevant point of time, you could have done this.
Should not
And that to the person is giving a scale PA, he is giving increment, he is giving efficiency bar. And you are maintaining one service book for all the various places where you are placing. And now ultimately, you put him in the DRDA, and when he retires from service, you say that DRDA is a society, no pension for you. Even if we accept your contention, Mr. Sharma,
Lordship.
from 1965 up to 1983, he was serving in the office of the Deputy Commissioner. 18 years. What is the qualifying service for pension?
Qualified, Lordship.
Qualifying service for pension?
10 years.
10 years. For that service, you'll get pension.
Yeah.
And not only that, it is the Deputy Commissioner's order by which he was placed in the DRDA.
DRD.
Not that the DRD had separately appointed him. It is noticed the original service book of the service book of the petitioner has been placed before the court. A reading of the service book make it discernible that the petitioner was initially appointed as a Mondal temporary as per a letter dated 9/10/1965. And thereafter he was placed in a scale of pay of rupees 125-4-145-EB-4-165-EB. In the process, the petitioner was allowed increment, and he was also allowed to cross the efficiency bar by various orders of the settlement officer Dibrugarh and Lakhimpur. Petitioner also appears to have been granted earned leave from time to time, as may be entitled to a regular employee. The assistant settlement officer makes an endorsement in the service book, which is undated. The endorsement in service book, providing that the petitioner would be facing retrenchment from the settlement office, which again, and accordingly, he was released from the office of the assistant settlement officer as per an order dated 1/8/1979. On being released, on facing retrenchment from the settlement office, the petitioner was temporarily appointed as an LDA also in a scale of pay for census work. Where again earned leaves, etc., benefit of earned leaves, etc., was granted to the petitioner. As per an order of the Deputy Commissioner dated 28, please give the complete date, Mr. Oh, you must be having the original.
Yes, sir.
That third page from the last, give the complete date. As per the order of the Deputy Commissioner dated 28, the petitioner was made to join in the office of the Mohkuma Parishad Tinsukia with effect from 1/6/1981, where he continued. Thereafter, as per the order of the Deputy Commissioner dated 26/5/1982, the petitioner was released from the office of the Mohkuma Parishad.
That earlier date is Lordship 28/5/81.
28/5/81.
Yes.
Thereafter, as per the order of the Deputy Commissioner dated 26/5/1982, and as per the approval of the governing body of the agency, the petitioner was appointed as an LDA temporarily under NREP work. There is also an order dated 26/5/1982 of the Deputy Commissioner Dibrugarh, by which in the interest of public service, the service of the petitioner was placed at the disposal of the project director DRDA Dibrugarh, where he continued to work till the date of his retirement sometime in the year 2005. The Deputy Commissioner to file an affidavit explaining as to under what service condition the petitioner was called to be an employee who is temporarily appointed, but was allowed the scale of pay with efficiency bar and increment, made to work from one office to another within the control of the Deputy Commissioner as per his own orders, where the petitioner continued to work in the same scale of pay and in the same terms. And thereafter, by another order of 26/5/1982, his service was placed with the DRDA Dibrugarh, from where he retired from service. The Deputy Commissioner to file the affidavit with reference to the relevant provision of law as to what would be the service condition of petitioner for his entire service period, which he rendered from 1965 to the year 2005. List 33. No, that way we are having the single bench. The photocopy of the service book along with the communication dated 19/20 Deputy Commissioner kept on record.
And, Lordship, I will have a copy, Lordship, as because only one.
You asked the
copy is with
Deputy Commissioner take a call. In what kind of service was this man?
Item 10 and 11.
In the circumstance, the respondents are denying pension to the petitioner by taking a stand that as the last service of the petitioner was with the DRDA, and the DRDA is a society registered under Societies Act, and therefore the petitioner would not be entitled to any pension.
May I get, Lordship, I can get the copy from the net.
If you want a copy of the order.
Lots.
Registration.
Item 10 and 11.
SS dismissed from service,
Sorry.
SSB Act, my lord.
Sorry.
The petitioner dismissed for service. This is the under SSB Act, my lord. Summary force course, my lord. In the earlier occasion, my lord, why the petitioner dismissed from the bio, my lord, the summary force court.
What is the issue, Mr. Pandit?
But the petitioner was the constable under the Sahasra Sima Ball, my lord, SSB.
Sahasra Seema
Seema
Bal.
Bal.
Yes.
He, due to the malot, some he was faced malot, he was dismissed from service malot. And
By this
by
kind
the
of a
summary force court.
summary court martial. Okay. Hmm.
And this summary for in the earlier occasion malot, this court, honorable court malot, made a query malot. Why the dismissal award passed by the summary force court, not by the general force court, malot.
Oh, yes.
My lord.
Your Lordship, the issue was in case of serious offense for which severe punishment was given by summary force court instead of higher courts, that is general force courts. Why such court?
What is the difference between a summary court and a general court?
In summary force court, commandant himself constitutes the court, and he can deals with the disciplinary issues up to the rank of head constable.
If the employee is up to the rank of head constable, it is the commandant who exercises the power and he constitutes the court of inquiry. In the what do you call the court, summary court. And if it is court martial, it is constituted by some higher official.
Some higher officials, in case of the IG rank or higher officials, forms panels of officers from different
And
categories.
where the delinquent would be up to the rank of any rank.
Any rank.
Okay, so now this person is up to the rank of Havildar. So therefore, you deemed it appropriate to constitute a summary court. In the procedure that is adopted, what is the difference between a court martial and a summary court? Because the word summary is, you don't follow all the procedures,
Your Lordship,
you follow a truncated procedure
your Lordship.
and arrive at your conclusion. That is normally the meaning of the word summary. In a summary court proceeding, is a truncated procedure adopted or you follow the complete procedure so that principles of natural justice is satisfied?
Your Lordship, there are different procedures.
No, Mr. Officer, what we want to know, in the name of summary court, do you summarily decide the issue? Or before deciding the issue, you follow all the required provisions of natural justice?
We follow the procedure as prescribed in the act. There are certain procedures for summary force court alone and for higher court.
In which provision we get those procedures?
Summary force court, the relevant section is section 82, 86 of the SSB Act. And procedure is given in rule 135 to rule 168 of the SSB rules.
So officer, our basic concern is the word summary. Summary, we already indicated, summary means a truncated procedure. You are dealing with dismissal from service of a person. Will a truncated procedure satisfy the requirement of natural justice? If it does not, then possibly whether it is constituted by the commandant or by the IGP, you are required to place the person under the regular court martial so that he gets all the benefits of the procedure of natural justice. This is what we are asking you. We are not distinguished on the basis of a rank of Havildar. There cannot be any rank that a Havildar will be dismissed because he is a Havildar. And if he is a man of a higher rank, he'll be given all the benefits of natural justice. It cannot be. Difficult to accept that submission.
Lordship,
It will violate Article 14. You cannot distinguish somebody by his position. That a man of a lower position does not require natural justice to be satisfied, whereas a man of a higher position is entitled to all the benefits of law. It can't be.
Your Lordship, all the
That-
procedural,
We agree with you that the summary court martial, summary court procedures are provided in the statute. We agree with you that the court martial procedures are also provided in the statute. But we do not agree if the summary court procedure is a truncated procedure which does not give the complete benefit of the principle of natural justice to be made applicable merely because the person happens to be of a rank of Havildar or below. That will be fundamentally unacceptable in law. If we accept that, that means all the person below the Havildar is at the mercy of the commandant. That by following a truncated procedure, I can dismiss you anytime I feel like. That will be the implication of your submission. Yes, now you submit what you have to say.
Your Lordship, after breach of discipline, evidence is collected.
Understand? Breach of discipline has to be established. It has to be established by following the due procedure of law, giving all the opportunities to the delinquent. If there is a truncated procedure adopted in this requirement, howsoever the allegation may be serious, that will not entail you to follow a truncated procedure.
Notice
Then
was,
all that the commandant has to raise is a serious allegation. Serious allegation, no natural justice, dismissed.
it was, notice was given, opportunity, all opportunity was given.
That's what we are asking. What opportunity was
All
given?
opportunities were given in the process.
What are the opportunities given?
He has been heard by the commandant after the incident. on
There are,
28/11.
Mr. Officer, there are two ways of hearing a person. One, a complete natural justice procedure. That is, he'll be explained his charge, he'll be allowed to produce any evidence, he'll be allowed to produce any witness. An inquiry will be there, their inquiry report will be there, etc. Other one, commandant will say, get hold of that man, bring him in front of me. Say what you have to say. Yes, I have heard you. Go.
All the opportunities were given.
What were given? Please point out. Because both are opportunity of hearing.
Hmm.
Show it from the records of the proceeding. Not from your paper, from the records of your proceeding, what was adopted. Was the person explained the charge? Was he allowed the minimum basic of adducing whatever evidence he wants to adduce? Was it given?
May I read? Lordship? Incident was happened on 27/11 after hearing was,
We are asking you what procedure and what detailed steps you had undertaken in the hearing given.
all the process are undertaken.
Mr. Officer, please be serious. This is a court of law, mind you.
Lordship.
When we are asking you what procedure, you are saying all the procedure. Don't cross the limit. Be within yourself. Yes, please say.
Notice was given
What was the content of the notice?
that hearing of the person was
Did the notice contain what are the charges against this man?
after hearing, charge was framed and charge sheet was provided to the
Where is the charge sheet? And summary court martial, you said, is section
135.
135,
Rule 135.
rule 135. So 135(1) says the officer holding the trial shall record or cause to be recorded the transactions of every summary force court. Where are the records? Records of every transaction.
The offense.
And what is the procedure for court martial? What is the procedure for complete court martial? Which rule?
It is prescribed in section 94 to 152 and rules 60 to 134.
So where is the procedure prescribed? You say for force court, it is 135. What is the corresponding provision of the rule for court martial?
Rule for general courts code.
Inner rules.
In the rules, it is prescribed in rule 135 to rule 168.
135 is summary force court. I am asking about the court martial.
Court martial means here SSB there is GFC.
Okay, GFC. Where is the procedure?
GFC is rule 160 to 134.
Rule 162.
Only 62 to 134.
162 to
Rule 62.
62 to 134. Okay. You read rule 66 and you also read rule 144, 45, etc. There is a distinct difference between the procedures that are adopted. What we are trying to point out to you from the beginning. For the what force code you said? For the force court, the opportunity that is available to the accused person is in much more detail and elaborate. If you read 144 and 145 for the summary court, it is very, very truncated. So this is what we are trying to point out, and you are saying no, and you are wrong. Because the rules itself provide the two different procedures. We are asking a question, how can you differentiate between a Havildar and below and a man Havildar and above? That even if the charge is the most serious, resulting in a consequence of dismissal service, if he is a Havildar, it will be the commandant who will conduct a summary court. And if it is above Havildar, we will conduct a forced court. Where do you get that principle of law? Is it available in any statute, any law? In other words, implication thereof will be Article 14 may come in that in the force, if a man is in Havildar or below, treat him to a summary court. Don't give him anything, any detailed opportunity. And mind you, 144 and 45 is you bring that man in front of the commandant, ask him whether you plead guilty or you don't plead guilty. Basically, that is a summary court. Whereas if it is forced court, you allow him all the defense, including an officer to defend him, allowing him to produce any material he wants. He will be explained the charge against him. There's a wide difference between the two. Tell us, Mr. Officer, under the SSB, under which provision of law it provides for, if a man is Havildar or below, don't give him very much opportunity subject to summary court. If he is above Havildar, give him everything. Produce that law. And mind you, be serious in your answers.
Lordship.
Otherwise, we may observe something against you.
Your Lordship,
If you are trying to put in any misleading presentations, we may put some observations against you.
Your Lordship.
Be fair.
Your Lordship, offense report was, I will, may I discuss the procedure?
Please give the answer. We don't want to hear what you want to say. We'll hear you later on. Give the answer. Is there any provision of law under the SSB applicable? We are repeating for the third or fourth time, mind you. If a man is Havildar or below, subject him to the summary court. If he is above Havildar, subject him to the forced court. Even if you want to impose the same punishment, same offense. Where is that provision?
Nice of it, that's it.
Please do. We can hear only one person at a time, not. Or else you submit. We'll hear you, then we'll ask the officer to sit down.
That's it.
So, Mr. Officer, you cannot speak anymore because the council is taking over.
That's it. I just wanted to point out one thing.
See, we can't have a chorus of a hearing before a court of law. When only one council is allowed, only one person will address the court.
Sorry. Lordship.
And you can elect between yourself who will address.
Your Lordship, in section 86,
86 section.
section 86. Subsection 3.
Power of summary court. Yes.
Summary.
No one is asking you the power of the summary court. We are asking you how you can differentiate by rank. I think this was your submission in the very beginning. If somebody is Havildar or below, we'll subject him to the summary court. If he's above Havildar, we'll subject him to force court. When do you get that law?
It describes that summary courts.
Can you hear Mr. RKD Chaudhary? I think better he takes over. His officer is of not much of a help for us.
Your Lordship, summary force code may try 86(3), it said that it may try any person subject to this act under the command of the officer holding the court, except an officer or a subordinate officer. That is up to the rank of.
So is this the interpretation that if a man is subordinate, howsoever the serious charge, howsoever is the ultimate consequence, he'll be only subjected to summary court? And if the man is above a particular rank, he'll be subjected to. All these provision states is that in the event of an officer who is of a higher rank, even if the allegation is a petty allegation, which otherwise could have been done by a summary court, you'll have to have a full force court. But in respect of a personnel who is below a particular rank, even the summary court can do it. That does not mean that for the highest of the allegation and the extreme punishment also, a man of lower rank will be tried only by the summary court without giving him proper opportunity of explaining his case. But in the event of a higher one, it will be. That is not the meaning, Mr. Officer.
Your Lordship, may I refer one rule position? Rule 54.
You can do anything but give proper answers.
In rule 54, 2, in clause 4, it says commanding officer, after going through the recorded abstract or evidence prepared by him or by another officer, try the accused summarily under section 56, that is summary disposal, or by summary force court where he is empowered to do so. Commandant is empowered under section 86, and here he applies his mind.
Mr. Officer,
Lordship.
we are also empowered to do many things. Does it mean we do everything?
Not, sir. Not,
Do you expect it?
Not.
If you expect, so tell us. We'll also do something. We are empowered to. 226 is a very wide power. We are empowered to do too many things. Shall I pass an order that we are not happy with this person be dismissed from service? Will it be proper if I do it? Similarly is the case with your commandant. Just because you are enabled to do something, will you do it without applying your mind, whether in this circumstance it is required or it is not required? Is a commandant also not in the same position? He has that power. But mind you, it's a service of a person. He'll be dismissed. And you don't even want to give him the minimum of the opportunity to explain his case. You will just call him guilty or not guilty. And enough of it. Go. It's a law not even prevailing in a police state. India is a democracy, mind you. Maybe it's armed forces. Armed forces are having some special protection, no doubt. Security issues, etc. But for a general service condition of the employees, can they be subjected to this method? Where is Mr. Ari?
He's on like in court number 11.
Okay, we'll have to hear him on this.
Yes,
It's a serious legal issue that has been raised. And if you say so, we may agree with you also. But all your forces below Havildar will be at peril, at the mercy of the commandant from tomorrow. Commandant can do anything with them. Commandant can ask them to do anything they are not required to do. If they don't do, I'm going to invoke this power, mind you. All that I'm required to do is to call you, say plead guilty or not plead guilty, and pass the order. Do you seriously feel that this is the position of law?
Lordship,
Do you seriously feel that this is the position of law?
the statute provides
Provides. Does the provide means you have to do it? I gave you the example. We also have some very wide powers. Does it mean in every case At random, you just go and exercising your power without doing anything, any reason, nothing.
Commandant should have applied his mind.
Definitely. And which provision of law under the Constitution of India may provide, either it is the SSB or any other organization, that you can dismiss a person just on your whims. Call him to my office, plead guilty or not guilty, dismiss. I have given you the hearing. You'll be taking the country back by a few centuries if you accept that. So be fair. If you're not giving, give him the opportunity. Put him to a complete procedure. Then you defend however he wants to defend. The end result of the order may be same, dismissal itself. But at least the procedure adopted will look fair.
Correct.
Don't you think so? And what will happen to the morale of these forces if this is inflicted on them? They're supposed to defend the country. What will happen to their morale? If that minimum protection is also not there, that we is always with the fear that I am under no protection of the law. Petty things, it's okay. Because the petty thing, the answer would have been a warning, a censure, or these, or some, that you do it. But not the ultimate. Dismissed. There possibly the commandant has to take a decision. What will be the ultimate outcome of this proceeding? If the outcome is something less severe, maybe you are right. Because Havildar and below, the number of employees will be much more. How many force court you can hold? So the law also empowers you that do it in a more truncated manner. Go back, reflect yourself, read the law, come back. And you also take the help of the Deputy Solicitor General.
I only add, your lordship, he has fired 6 rounds indiscriminate.
Mr. We are not on what he had done. We are not on the ultimate order. We are on the procedure. What actually if he had not done? You feel he had done. If he feels he had not fired, then where is that opportunity to him to prove himself that he had not fired? Don't you think it is necessary? If today I hold you in contempt for some reason, don't you think it is necessary that I'll also give an opportunity why I intend to hold you? Or I can take a view that this officer is conduct is contemptuous. Convict him for contempt. Can it be done? Same is that one. Hearing remains inconclusive, Mr. Your name, please.
My name is Padmanabh Chakraborty,
Mr. Padmanabh Chakraborty, your designation.
Deputy Commandant Law.
Deputy Commandant Law is present before the court. Although Rule 66, 56, no, Section 56, 86 of the Sashastra Seema Bal Act 2007 had been referred to impress upon that the commandant of the battalion
Commandant of the battalion.
has the power to bring about a summary court proceeding,
Summary force court.
summary court, summary force court. As because the petitioner concerned is a personnel of the rank of Havildar or below. Whether the same power can also be exercised in respect of an official who is below the rank of Havildar, but the charges are serious, which may ultimately result in the punishment of dismissal from service. Or in the event the charges are serious, which may entail the punishment of dismissal service, the person concerned is required to give a more elaborate opportunity of hearing. That is to follow the procedure of the force code, general force code procedure. The only reference made is to section 86 is section 86(3), where which provides that a summary force court may try a person subject to the act under the command of the officer holding the court, except an officer or a subordinate officer. No, not that. Where is it? Where is that, Havildar?
Except subordinate officer means it is up to the rank of head constable.
Okay, fine. Answer the question. Based on 33. But this is a serious question you are raising. It will have an impact on the entire force, mind you. If you happen to dismiss this petition, the implication of the High Court order will be you can do anything with your
Yes,
men
right.
below Havildar. Irrespective of what will be the implication. So you understood the question set for you? Have you understood the question? Please answer on the next day. Next item.
Item 12,
And ask Mr. Argis, we want to hear him on this important, it's an important question of law. We have to hear him also. Record.
My pleasure, Your Lordship. Your Lordship may remember my learned friend was to obtain instruction. On the last occasion, Your Lordship has taken a view regarding, well, this is a matter where. a panel-
Not view, tentative view,
My lord,
tentative view.
tentative.
View would have resulted in a judgment.
Yes, my lord. No, in fact, my lord, Your Lordship has given my learned friend some opportunity. This is a matter, my lord, where a penalty was imposed to a superintending engineer. The penalty is, my lord, period of suspension to be treated as on duty only for the purpose of pension and subsistence allowance. And
Period
hold
of suspension to be treated as?
as on duty only for the purpose of pension and subsistence allowance.
Huh.
And the whole of petitioner's DCRG to be recovered and pension limited to 50%. And that was passed, my lord, before the petitioner was still in service.
My lord. Yes, I have examined this.
Can it be done?
21, my lord, of the pension manual.
No, I think rule 7, sub-rule 4 or 5 allows you to recover the pecuniary loss caused to the government.
My lord,
But can the pension be touched?
we can, my lord, if we would have done it after retirement.
After
We-
retirement, under 21, you can do it.
Yes, but.
Because 21 is withholding the whole or part of the pension or something like that.
Yes, my lord, but
But before he retires, can you?
before he retired, my lord, we passed this impugn order. I have,
No,
that-
but that's why I say, can it be done? So, Dhor, we can do one thing. We can set aside and send it back to you.
yes, my lord.
In the meantime, we can invoke 21.
Only one thing, my lord. My lord will give us liberty, 21/4.
shall not be in respect of any event which took place more than 4 years. During this pendency of this writ petition, my lord, the 4 years is left. He has retired in 2017. Now we are in 2020.
So Rule 21 purpose is, suppose you could not complete the proceeding,
Yes, my lord.
that case also you'll have to look into because otherwise disciplinary proceeding can be in respect of offense which may be committed at any point of time.
At any point of time.
There is no time limit.
Right.
But moment it is a order under 21, even if the proceeding continued from before, but to convert it to a proceeding under 21, this requirement of 4 years comes in. Under 21, either you can initiate a proceeding or you can continue with a pending proceeding. Both are permissible. If you have to initiate a proceeding, the requirement of event happening within 4 years is applicable. Otherwise, you cannot. Similarly, in the event of continuing an earlier proceeding, which earlier you could have made it in respect of any event which may have taken place at any point of time. But moment you continue under 21, the embargo of 4 years comes in. And once it happens in this way, you can invoke the provisions of Rule 21
Rule 21.
and can also withhold something from the pension.
Right.
There is no difficulty in understanding that.
Right.
But before a person retires, again, that power under 21 to withhold from the pension is again circumscribed by event must be within 4 years.
My lord.
So now, by passing an order before that man retires, in respect of withholding from pension, you are usurping a power which you otherwise would not have had of doing away of the requirement of the event taking place 4 years prior.
My lord.
And you are also imposing that punishment in respect of events which took place prior to 4 years. It will be not permissible.
No, my lord, shall not be in respect of event which took place more than 4 years before such institution.
Such
Institution. Meaning thereby, my lord, my understanding, my lord, the event.
So then also in a disciplinary proceeding, how can you touch the pension?
2017, my lord.
And because pension is a code, its entire provisions are under the
Pension manual.
pension rules.
My lord, here 21 may I read by once. The governor of Assam reserved to himself the right to withholding or withdrawing of pension or any part of it, whether permanently or for a specified period, and the right of ordering the recovery from the pension of the whole or part of any pecuniary loss caused to the government, if in a departmental or judicial proceeding. So, my lord, departmental proceeding it was there, my lord.
Pension, that's right, pension rules. Mr. Dhor, I think we'll have to continue on some other day.
My lord.
Uh,
Yes, my lord.
Some.
Thirtieth, my lord.